Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-5152 et al. Coalition for Humane Immigrant Rights et al. Appellants versus United States Department of Homeland Security et al. Ms. LaPointe for the appellants, Mr. Van Goswami for the appellees.
Good morning, everybody. Good morning.
Good morning, Your Honors. May it please the court, Michelle LaPointe for the plaintiffs' appellants. I'd like to reserve 3 minutes for rebuttal, please. For the past 80 years, the government has decided not to require universal non-citizen registration. And the government has never implemented universal registration combined with a carrier papers requirement. But that all changed on April 11th of this year, when defendants began implementing the interim final rule that plaintiffs challenge in this case. By defendants' own admission, the IFR impacts at a minimum between 2.2 and 3.2 million people who for the first time are subject to registration and who face criminal prosecution if they fail to apply to register.
Let me tamp down a little bit on that last comment about for the first time facing registration, because we have the Alien Registration Act of 1940 requiring all aliens in country over 30 days to register and be fingerprinted. Then we moved to the INA in 1952, and then they added certain things like 14 years and older must apply and carry the papers if you're 18 and older, and then also the misdemeanor. Now, mind you, even though it said all aliens, there were categories in which people filled out the form, and not necessarily everybody had a form that applied to them. And now we're moving to an interim final rule where they would consider it filling the gap. But you start with all were required to do so, even though some didn't have the form. So mind you, you might not have a form to do it, but it at least still said all are required to do it. So that I guess I get to what the intent was.
Right. Your Honor, it is true that the 1940 statute established a requirement to apply for registration for non-citizens. However, the defendants through the decades have narrowed that requirement by not having a form or a method available for a large swath of non-citizens to register. So they made a policy decision to channel non-citizen registration into the immigration process. That means only if you were eligible for and applying for certain immigration relief or benefits did you have a method to register. Therefore, there was no way for large numbers of individuals who are undocumented and had no interaction with the immigration system before and were not eligible for any immigration relief to register.
So you would take the position that if there was not that form or category for them, that even though it said all are required to register, they would not have been in peril of the law.
Right, because there was no means for them to apply for registration. And so there would have been no way for them to be criminally liable for willful failure to register during those years until April 11th of this year. And defendants acknowledge as much in the IFR, and the district court recognized as well that this was a big switch in policy. A big switcheroo is what the district court described it as. And that's because, as I said, for these decades, it was only through registration, through immigration processes, that there was an available method of registration.
Please go ahead.
Something is changing, no question about it, but your opening described what's going on as the creation of a new rule or duty. I read the statute the way Judge Childs does, and if that's true, then it seems like a more fair account of what's happening is the change is that the government is ending a long policy of unlawfully not enforcing a legal duty that on its face covers all aliens.
Judge Katsas, even if that were the case, accepting that premise, the government still needed to go through notice and comment rulemaking in order to implement this IFR. And it did not do so in this case, and that alone dooms the rule. This IFR imposes new substantive burdens that did not exist for the 2.2 to 3.2 million people who previously had no method to apply for registration. It encodes a substantive value judgment about what the government, what DHS in this case thought was important in terms of how to register people, who should be required to register, what type of information should be required of them through the registration process. And it trenches on substantial rights and interests of the individuals who are newly required to register because they previously had no method to do so. So under this court's precedents, that was certainly enough to require notice and comment and to allow the public to weigh in on these important changes before the rule took effect. And that's setting aside the arbitrary and capricious nature of the rule itself. But we think that at a minimum, they had to allow the public to weigh in on these substantial changes.
One point you have, which is a good one, is that the rule does expand the category of information that has to be provided, and that's new. But all of these requirements, the ones in the original statute and the expanded ones in the rule, are in the nature of the government is requiring a private party to give the government information in order to facilitate enforcement of other legal obligations, right? You can only stay in the country for X number of days. You have to comply with your visa, whatever it is. The information, the registration helps enforce that. Why isn't all of that, the new stuff and the old stuff, procedural?
Well,
So, you had to fill out a form, I assume, for oral argument, and you had to give us a bunch of personal information to facilitate, we can track you. If something happens in the morning, we can call you, whatever it is. It's something of that nature.
right. So I think it's important to zoom out a little bit and understand that the scope of individuals who are now required to register who previously didn't have a method to do so is so large that is sort of in itself is enough to have required the public to comment. But I think that it's important to know that the government here, defendants have said that this is a tool of immigration enforcement. So unlike the folks who previously had a method to register because they came through the visa process and the government ostensibly could have been tracking their compliance with exit requirements under those visas. Now we're talking about an entirely new swath of individuals who entered without inspection. That's pretty explicit.
In order to facilitate enforcement. But
Right.
to me, that tends to cut for procedural. I mean, if say you're on the front end applying for a visa and the government says, here's all the information you have to give us when we consider your visa. That sounds procedural to me.
I think the distinction is that these individuals who are newly impacted by the rule do not have any eligibility, have not applied for any immigration benefits. And so it is solely for the process of facilitating deportation, or as the defendants might say, self-deportation, which I think takes it outside the category of procedural. It is impacting fundamental rights, including members of plaintiffs' associations' First Amendment rights, their Fifth Amendment rights against self-incrimination because they're required to report on any criminal activity, including uncharged criminal activity, without a method to assert their Fifth Amendment rights. And they're experiencing a chilling of speech because of those requirements to report on their activities in the context of what's going on currently with the targeting of individuals, including non-citizens, for First Amendment protected activities.
I'm a little confused. What speech is chilled?
So a number of the plaintiffs' members have stated that they are engaged in political organizing activities on behalf of immigrants' rights causes. And they stated in their declarations that by having to disclose this through the new registration process, they will be chilled and continuing to assert those First Amendment rights, particularly in the context of everything that has been happening in the targeting of non-citizens for their expressive activities. So it's kind of core.
But
for-
is that a consequence? Let's divide the form into two things. Most of the information found on there is already required by statute, including the list of activities. And then there's a couple things, including confess any crime you've ever committed that's been added. Put aside the addition. The requirement to disclose activities already exists in the statute. You do not challenge the constitutionality of the statute.
Correct.
So then how, if it's constitutional for the statute to require it and the form just says, if the form said, give us all the information the statute requires, here's the statute, would you have the same challenge?
So that's correct that we are not challenging the constitutionality of the statute through this lawsuit. But by using this method of registration, the government made a policy choice to include all of these categories of inquiry.
Hang on a second. Again, I want us to pretend, let's focus only on things that the statute already requires. Now imagine this form said, please give us all the information required by the statute, cites the statute, and then lists the excerpts from the statute, all the things it requires. You would have the exact same obligation to challenge or to list your activities.
Right.
Would you have the same injury? Would you be asserting the same injury then if the form said, just give us what the statute requires?
I think that it is the combination of what the regulation is.
So the answer to my question is no. It's that they ask you for what the statute requires and something else?
Right. So it is by requiring people to report on those activities that the statute does list out that, as Your Honor says, include all the activities that you've been involved with within the context of what is going on currently with the targeting of non-citizens for their political speech and their First Amendment protected activity.
But then that doesn't, okay, so if the problem isn't really the content of the form, put aside the addition, we're putting those on hold for now. So if we're just focused on what the statute requires, and this will say the form, to the extent it just duplicates what the statute requires, you're saying what makes the rule unlawful is separate enforcement activities that the government is taking?
I think that's part of it because we're not.
Yeah, what else is it? Because I keep trying to understand
Right.
your argument about your combination argument here.
Right.
It's not, what else is it on top? I mean, I'm not quite sure how we can look at enforcement activities
Right.
as a means of challenging a rule to the extent it duplicates statutory requirements. That's where I'm having trouble.
What it speaks to is the cognizability of a First Amendment harm. So it is requiring them to report on
The
it.
statute, okay, so so your point, if I understand your point right, and tell me if I don't, it's that not challenging the statute, which says, lists a lot of things, including all your activities, not challenging that. To the extent the form says it's the same things as the statute, we're not challenging that. You haven't brought a lawsuit against enforcement activities.
Right.
It's violating the First Amendment or anything, so you're not challenging those. And the rule doesn't say anything about those enforcement activities out there. So what is your challenge? What is the rule doing to harm, say, these speech activities? What is the rule doing? Statute's not doing it. You're not challenging the statute is doing it. You're not challenging the enforcement activities. But the rule's not adding anything at that point.
The other thing that it is doing is it is explicitly form or process that will be used for immigration enforcement, as defendants have stated in the rule itself and in comments about the purpose of the rule. So unlike
But
when
isn't
this
that, I mean, sorry, explain to me the legal grounds on which we could say it's unlawful for the government to use the information it's lawful for it to collect in an immigration context. It's unlawful then to use it in the immigration context.
sorry, if it's
They're
unlawful.
collecting this. I mean, this is the statute is sort of part of the network of laws that we have regulating the conduct of people who are in the United States who are not U.S. citizens or lawful residents, right? So people who are here, whether it's diplomats or people here on tourist visas, or everything ranging from the tourist visa to people who've entered without documentation and have remained in the United States without lawful authority. All right. So, and your concern is how they're using the information? That's what you're saying?
We are not challenging how they use it, as Your Honor points out. However, in defining the cognizable harm of having to report on it, it is important to look at the context of what's going on and how they've been using this information.
I'm trying
But
to
I
think
think,
how you can have a legal harm. It has to be a legally cognizable harm.
yes,
If you don't challenge any of the things, any of the actions that you say cause that harm. Do you have an example where someone claimed an injury, but everything that caused the injury they agreed was perfectly lawful?
so
Not challenged for these, I'm going to equate not challenged as lawful for these purposes.
So I'd have to think a little bit more about the second part of Your Honor's question. But I think if we look at DC Circuit precedent on what constitutes chilling, a cognizable chilling effect on First Amendment rights, the standards set out by the Chaplaincy of Full Gospel Churches case, plaintiffs have to establish that they are or will be engaging in constitutionally protected behavior to demonstrate that the government activity would chill this conduct. And multiple plaintiffs in this case have done so. Louisa from Churla, Gouvelia from Make the Road, and a lot of other plaintiff members have talked about, they've stated specifically that they are engaging in constitutionally protected activity, core First Amendment political activity and speech activity, and that they are currently experiencing chilling based on the requirement to expose that conduct through this form, which is only
I thought you said
for the purpose of immigration.
It's not the question that's chilling them. It's not the question or the obligation to answer the question that's chilling them. It's not the obligation to answer this question on a form that's chilling them, because you said just the form doing what the statute requires is not the source of chill. It sounds like it's the enforcement activities that are chilling them.
Their position is that it is the obligation to disclose it through this form that, again, has no sort of ameliorative effects, is not simply an inventory like the statute was first conceived of non-citizens.
Well, there's nothing in the statute that says, I get that people talked about it that way, although sort of questionable. I think that's really what it was doing, was collecting assets, information about assets. There's nothing in the statute that restricts its use, is it? Is there?
That restricts, I'm sorry?
Restricts the use of the information?
That's correct.
Is there another statute that restricts the use of information?
The information that would be received through the registration process, not that I'm aware of. We do talk about other statutes in the immigration benefits context that have more restrictions on information that protects the confidentiality of information submitted, and that's through, for example, VAWA or the U visa context, but through the registration statute, not that I know of.
Why are we talking about chilling at all in a case where you haven't raised a First Amendment claim? Chill is a theory of a First Amendment harm. Here, your primary contention is an APA question about whether this change is substantive or procedural, and why is chilling relevant to that?
Your Honor, it's correct that we have not brought a freestanding First Amendment claim in this case. We do talk about in our complaint the failure to consider First Amendment and Fifth Amendment issues as part of the arbitrary and capricious challenge in the APA. And there are other cases outside of the circuit that have considered in the irreparable harm context constitutional injuries. For example, the Mock v. Garland case from the Northern District of Texas, the Alabama versus U.S. Secretary of Education case from the 11th Circuit. These are cases where constitutional harms were considered as part of the APA analysis, and we think that it is appropriate to do so here. There's certainly no prohibition on doing so. Defendants have not cited any cases where this is not permitted. And again, we just think in addition to the notice and comment issue, it goes to the arbitrary and capricious nature of this.
So I get you have plausible theories for folding it into arbitrary and capricious and maybe irreparable harm. Just on the notice and comment, are you contending that the separate enforcement activity could make what would otherwise be a procedural requirement into a substantive one? Or you're just talking about chill for those other issues?
I think it goes to the notice and comment claim as well in the sense of making a substantive value judgment about the purpose of the registration system and the criteria for setting it up, and the fact that it trenches on individuals' First and Fifth Amendment rights and interests, which is part of the test in this circuit about whether it is procedural or legislative rule, not just rights, but also interests. So it goes to both the notice and comment claim and the arbitrary and capricious claim. I think we can, I understand. Oh,
What's the extent of the post-promulgation comments that are being offered here? Do you not feel like that's effective? Because we are in an interim rule as opposed to a final rule.
Right. So the government didn't give people, the public, the ability to comment, of course, before the rule went into effect. And so to the extent that comments were submitted, which are not part of the record here because it was a pre-enforcement challenge, none of those comments would have been considered as part of the agency's rulemaking. And they have not subsequently modified the interim rule in any way. So it is as promulgated in the Federal Register is the language that ended up being the rule here.
You've also asserted that the IFR, not the INA, actually exposes the non-citizens to the criminal liability, but the criminal liability was in the INA.
That's correct, but it goes back to the lack of a means to, and the statute says apply for registration, which I think is important here.
And be fingerprinted.
Correct. That is correct, Your Honor. But one cannot apply for registration if the government does not provide a means for doing so. And the CFR, 8 CFR 264.1 talks about prescribed forms that count as registration documents or evidence of registration. So without a prescribed form to do so, these millions of people previously did not have a method to register, wouldn't have been exposed to criminal.
Give me a sense of what the commentary for notice and comment would be. In other words, as I started out in this hearing about that you had the registration requirements way back from the first act and then superseded by the INA. And then we got executive order and then we now have this interim rule. So the opportunity or the principle to register has always been out there. So if you go to notice and comment, I don't see the policy of wanting that requirement to change. But what would your commentary be about it? Because it sounds to me like you're more focusing on, I'm worried about these 2.2 or 2.3 million somehow getting caught up into all of this and potentially there being enforcement against them. And that sounds like an educational campaign, you know, from one standpoint of, yes, the rule goes into effect, but we don't implement it we don't implement it or make it be really effective for 4 months or so that there can be the widespread campaign by groups such as yours and others. And so what would notice and comment for you achieve?
Your Honor, it would achieve the purpose of notice and comment rulemaking under the APA, which is to allow the public to have offered their input on this policy choice here. I think this goes more to the arbitrary and capricious argument, but it's clear under this circuit's precedent that a change in policy as fundamental as the one at issue here requires the agency to acknowledge that the previous policy existed and they made a choice to change it. And then, of course, to engage in reasoned decision-making to underlie the new rule. We can look at the American Wild Horse Preservation Campaign case. Physicians for Social Responsibility make clear that whether it's a formal policy or an informal policy, at a minimum, the agency had to acknowledge the immense change that it was undertaking here and provide a reasoned explanation for doing so. And here, the agency just completely glosses over that requirement. And again, just sort of goes back to the existence of the statute to justify this change. But that does not pass muster under this court's arbitrary and capricious precedents.
On the question, on the line between substance and procedure, it's not the clearest line ever, but we have some cases suggesting that one consideration, at least in close cases, the question might turn on the extent of the burden. Government cites this JEM broadcasting case. It's an issue of degree. Are the burdens so grave as to warrant notice and comment rulemaking? Do you agree with that formulation?
I agree that is part of the test, certainly. But if you look at the cases where this court found that a rule was procedural, you'll find that it really, they hew a lot closer to this idea of it only regulates the manner in which an individual presents himself to the agency, certain things like deadlines to file.
I'm going to ask you to assume two things that you disagree with, but stay with me. Okay, suppose I think that the kind of duty here, providing information to the government that helps the government enforce, is in the gray area. It's maybe substantive, maybe procedural. It's an edge case. And put aside the question of harms from enforcement. So I'm thinking about, is this a substantial, serious, heavy burden, or is this kind of a record-keeping thing? And just looking at the form, I mean, how long do you think it would take for an average alien to fill out this form? Name, address. And the hardest part of this would seem to be police and criminal record, and that's directly out of the statute. And the rest of it seems pretty pro forma.
So a few things to consider there. First, as plaintiffs have pointed out, this is an online-only form available only in English, and that in itself makes it inaccessible to a large number of people who can't access the internet or speak English. In addition, though, looking at the burden on individuals to actually fill it out, there is, and I don't have it at my fingertips, but I believe it's about an hour that the government estimates in the IFR that it would take them, in addition to the time to go provide biometrics, and the lost wages, of course, that would be entailed with going through this process. So that is certainly part of it. But I think if we're looking at the other cases where this court found that a rule was procedural, they just are very far from this IFR in the sense that they actually talk to issues of agency efficiency. I don't hear the government saying here that, yes, they talk about law enforcement objectives and improving law enforcement outcomes, but it's unclear to me how the requirement of submission of a new form, an entirely new process for U.S. citizenship and immigration services to undergo and to process is somehow increasing agency efficiency. That's actually a new burden for the government in addition to the non-citizen, and that part is a bit unclear to me as well. And so it's just really, I understand the procedural legislative line is sometimes a bit, there are close calls. This is a bit blurry, but in this case, I think it is so far from the procedural side of the line that the agency absolutely had to allow the public to comment.
Thank you.
Can I ask you a question about irreparable harm? Are you aware of any case where we have issued, or we have stayed or asked public district court, they should have stayed, they erred in not staying or enjoining based just on a notice and comment violation?
I'm sorry, was Your Honor's question whether a district court has?
Whether this court has, is there any precedent from this court or another appeals court addressing whether a notice and comment violation, put aside your arbitrary and capricious challenge, I don't forget that you have that, I got that, but for your notice and comment argument, that alone inflicts irreparable harm that would support a preliminary injunction for stay?
Your Honor, I'm looking back at the notes. I don't think we had an example in the preliminary injunction or 705 stay context, although I'd have to confirm that. Of course, I'm thinking about Mendoza versus Perez, but that was not preliminary posture.
Yeah, sure. But I mean, final relief could happen there. I'm just talking about where you really have to have the irreparable harm. And I'm just wondering how notice and comment violations inflict irreparable harm.
I believe that we did not cite a case precisely in that posture, but I'm going to confirm that.
Certainly for arbitrary and capricious it happens, but yes.
Right.
Okay. And then I get, as the district court judge said here, and Judge Katsas has noted that, this is a big change because there just hadn't been a registration opportunity until this form, or for the most part hadn't been unless you were going through the immigration process. If when the statute was first enacted, this rule had been adopted, so you don't have that time gap. You don't have that lapsed enforcement and then now new enforcement. Well, would you have been able to challenge it then? And put aside again the provisions that go beyond what the statute requires.
I think it would have been a much closer call. I think it's
would have been the challenge.
It would have depended on what the agency decided to put in the registration form and requirements.
Let's assume, again, for purposes of my question, that it's only things that are listed in the statute. It's this form, but only things listed in the statute.
In that case, it may not have been, we may not have been able to challenge the initial rule in Your Honor's formulation that emerged from the statute if it was precisely on all fours with what is in the statute. I think we'd still want to look at, the test for a procedural versus legislative rule. And in that case, I think there's a possibility that we would have still been able to challenge the rule as requiring notice and comment rulemaking. And of course, there may have been other arbitrary and capricious, et cetera, but it would have been a lot closer call.
Would you have had irreparable injuries from the rule? Assuming you were bringing notice and comment and arbitrary and capricious, not quite sure what it would be, but again, I get here there are things that go beyond the statute, and that's an important part of your arguments. But if we don't, as to the things that are covered by the statute,
I think that also would have been a lot more difficult. Given the passage of time and the decision of the agency in this case to abandon a prior policy, that is part of the reason we're arguing.
Okay, I get that can be grounds for APA challenge. So what I'm struggling with is how, again, putting aside the questions that go beyond the statute, because the all crimes thing is big. If we take that off the table, I'm struggling to see what the irreparable harm would have been. Why it changes based just on this time lapse. Do you have a reasonable reliance interests in like a standing statutory obligation not being enforced or implemented? That's just the difficulty of this case.
Yeah.
The statute's been there a long time, as Judge Childs pointed out.
Right. I think that's why we have to go back to the context of the way that the obligation has evolved over the years. And that ends up feeding into the notice and comment claim in addition to the arbitrary and capricious claim. And it speaks to irreparable injury because for the first time and suddenly a new obligation is being imposed on these millions of individuals. And I think that is an important aspect that would not necessarily have arisen had they implemented an interim final rule right after the passage of the statute itself.
Just on the notice and comment portion, how do you feel that this does not fit the procedure exception to notice and comment when it's like the agency organization procedure or practice in that regard?
I think, Your Honor, it's because of the things we've been discussing that this is imposing substantive burdens that did not prior to the IFR exist. Encode substantive values in terms of what the agency is seeking and why they decided to implement it at this point and so suddenly, and the substantial private rights or interests. I also wanted to point out that the large swath of individuals that are impacted here plays into the determination of it being a legislative and not a procedural rule as well. I think under this court's precedents, when we're talking about the impact on, for example, thousands of employers that this court talked about in Chamber of Commerce versus U.S. Department of Labor, 174 F3rd 206. We're talking about such a substantial public impact that it takes it over the line from procedural to legislative.
You mentioned that they should mention why they entered this rule and the impact and why now. Why is all that important? Again, with the overarching that this is not a new law, so to speak, in terms of just non-citizens registering.
Your Honor, that speaks to the arbitrary and capricious analysis and the requirement therein that the agency has to acknowledge the change and not sort of gloss over it the way they've done with this IFR, and to offer a reasoned explanation for it. Just sort of fundamental
And you
principle.
don't see that as gap filling, meaning that these people now have a form that didn't otherwise fit into these other categories.
Right. We think it absolutely required them to go through the analysis under State Farm, to consider the alternatives, to take into consideration the costs and the benefits under Michigan versus EPA, and their failure to do so here rendered it arbitrary and capricious.
And are you aware of any of your clients actually having filled out the form and experienced any repercussions?
We do not have any information about that. Currently, it's not in the record. This, of course, was a pre-enforcement challenge. So the obligation to fill out the form had not arisen by the time the plaintiffs requested preliminary relief in this case.
Thank you very much, counsel. We'll give you your time on rebuttal.
Thank you.
Good morning, Your Honors. May it please the court. Karthik Vengaswamy on behalf of the United States. Your Honors, I would like to just stress that, as we pointed out in our brief, the most important thing here is standard of review. And as under this court's precedent, the issue is it's an abuse of discretion review over the district court's decision ultimately to find no irreparable harm. And as we have argued in our brief, and as I'll continue to argue here, the district court was correct in finding that there is no irreparable harm. In fact, as Your Honors have discussed previously with my colleague just now, it seems that they have essentially conceded that any true harms in this case arise out of the enforcement or the extraneous factors, the statute, the enforcement, all of those things are the harms from which they're actually complaining and the harms of which they're actually saying are irreparable. As Judge Millett, as you asked, there is no harm arising from the rule itself, and they have not been able to point to any harm arising.
No, they answered that in response to my questions that assume the form only duplicates the questions of the statute. But this form goes beyond the questions in the statute.
Your Honor,
In particular, requiring people to report any crime ever committed anywhere in the world, whether they were, even if they weren't arrested or prosecuted or convicted. Nothing in the statute requires that much, does it?
Your Honor, respectfully, under 8 U.S.C. Section 1304, little 5, the statute specifically both authorizes and directs the Secretary to ask 4 broad questions and such additional matters as may be prescribed. The statute.
Sure, but the statute itself didn't make the judgment. I mean, those additional matters have to be within reasonable bounds under the APA and constitutional bounds. And so requiring everybody on pain of prosecution or deportation to confess to the government every crime they've ever committed.
Your Honor is correct that the specific requirement that they confess to other crimes outside of this jurisdiction or not from which they're arrested is not specifically enumerated in the statute.
Right. That's the point.
But the statute does encompass asking for the police and criminal record of the
That's,
individual.
I get that. But all crimes never known by police, not in any criminal record, is a very different inquiry.
Your Honor, respectfully, it's not that
Crimes
different.
committed outside United States jurisdiction?
Your Honor, respectfully, it's just an expansion of what's already in the statute and falls under both the catch-all and the police and criminal record sections.
No, it is not. It is not. If I said, tell me every crime you have ever committed in your life. Now, I assume if I ask you if you have a criminal record, the answer is going to be no, because you're a member of the bar, and maybe even also for police record. I'm assuming these things, right? But if I say, have you ever committed any crime, recognizing that speeding on the George Washington Parkway or the Baltimore Washington Parkway is a crime, not a civil infraction. Littering in a national park is a crime. You know, that's asking you to confess to things that no governmental authority is aware of. That is a big step. And it's also a big step closer to the Fifth Amendment than disclosing police and criminal records, which are matters of public record.
Your Honor, I agree with you that that would be asking the court, asking in this hypothetical me to confess, although I do believe that the
I'm
bar
not really asking you to confess.
I do believe the bar application actually does ask you.
I do take the Fifth on limits on the Parkway sometimes.
No, I do actually believe the bar applications ask you that. They ask you to confess to anything that you've ever done, regardless of whether you've been convicted of it. I think that's actually a question, and it is a procedural question. Again, going to the collection of information that then might be used in enforcement. But even agreeing with Your Honor that specific
So I was
question.
just clarifying what her answer was, though. It wasn't.
Absolutely,
We
Your Honor.
definitely challenged the.
And even conceding that point, though, the harm still comes from enforcement of the statute. The harm still arises out of the statute directly, not out of the rule and not out of the form. The form is not causing any harm here. The rule is not causing any harm. And so the district court's decision
It's a little hard to separate the confess everything you've ever done, and now we're going to use the information on that form to go after you either for deportation or criminal prosecution or both.
Your Honor, if they had made that argument in either this court or the court below, if they had pled that there was any reasonable or imminent danger of that specific question being the cause, but that's not what they're saying
They
here.
definitely challenged on Fifth, that's the basis for their Fifth Amendment irreparable harm claim.
Your Honor, for the Fifth Amendment claim, but as Judge Katsas pointed out, they haven't actually made a constitutional claim.
Oh, but they
And
said
as
it's an APA claim includes contrary to law. That would include unconstitutional actions, would it not?
It would, Your Honor, but a Fifth Amendment claim isn't
It
only.
might even be arbitrary and capricious to ask people for information. I want to get ahead of ourselves. I'm not saying that itself would actually violate the Fifth Amendment, but it rubs a lot closer than anything in the statute does. And so, just to be clear where we are on this, but they can bring an APA challenge that says this is contrary to law They could say constitutional avoidance through the statute is not including that in the authority. They could do that.
Your Honor, they can bring the challenge, but I think the crux of the assessment at this point is the fact that this is a preliminary injunction that's up on appeal and not a 705. This is not a final rule. This is not a 705 challenge. This is a preliminary injunction challenge that was denied by the district court. And the district court determined, weighing law and fact, that there was no irreparable harm in this case, and there's no abuse of discretion in that finding. But even
I just have one more procedural, I'm sorry.
Go ahead.
A procedural question that I'm really kind of confused about what exactly is before us. So what's certainly before us is the district court's initial denial of preliminary injunction on the grounds of lack of standing. That's before us.
yes, Your Honor.
Then the district court, on their application for injunction pending appeal, said, oh, no, not a standing problem, but an irreparable harm problem. In evaluating under an abuse of discretion the denial of the preliminary injunction, can we consider the district court's analysis of irreparable harm, which was only on a injunction pending appeal, not on a separate request for relief from the parties?
Yes, Your Honor. I agree with you that there is some confusion given the fact that there are 3 separate appeals in this case. But ultimately, under the case law, this court can consider any of the rulings from the court below and all of the issues that are in the record. And so this court can and should consider sort of both of the district court's decisions. And I think both parties.
Is that true for preliminary injunction discretion, which as you said is abuse of discretion analysis, that we can consider if the only viable notice of appeal before us, which I thought was your argument, was the first notice of appeal, where the district court, and that record, that preliminary injunction record coming up to us doesn't include the irreparable harm analysis. We have to bring a different record up to us, a later record up to us to consider the district court's analysis of irreparable harm.
In this case, no, Your Honor. If all of the procedural rules had been followed appropriately, the second notice of appeal would not have been a second notice of appeal. It would have been part of the record in this court, because what should have happened is they should have, under Federal Rule of Appellate Procedure 8, they should have then filed a motion for a stay in the district court pending this court's determination, instead of being a second appeal. And so in that motion, that would have rolled up everything, including the district court's analysis. I'm going to say the second go round for just as a shorthand, but ultimately all of the facts are in the record before this court. I mean, this court, I believe, should send a message that this sort of gamesmanship and multiple appeal filing is
I don't think
problematic.
it's gamesmanship. Like, to be clear, there's no reason to make an accusation like that. It seems to me it was just a very confusing procedural posture, and they were perhaps trying to protect their rights and to get all these things in before, up before us. And so they appealed what they could appeal. They didn't know the district court was going to switch horses.
I stand correct. And I certainly didn't mean to accuse them of anything, Your Honor. More just to clean up the record and to make it clear. I believe this all should have been one appeal, but
if it had been an appeal before the district court rules on irreparable harm, then it's not before us? Or is it?
Because
what can we consider that postdates the preliminary injunction record?
Your Honor, if this had been sort of by the book, this would have been up on a Federal Rule Appellate Procedure 8 motion.
They did file Rule 8 motions, and those have already been ruled on by this court. But I don't know that a Rule 8 motion can we rely on things told to us for the first time in a Rule 8 motion to evaluate the district court's exercise of discretion on the record that was before the district court at the time the district court ruled? That would seem almost unfair to district courts.
I believe you can, Your Honor, because again, it's all part of the record before this court, and this court has the discretion to consider anything that was properly presented to the district court in making its determination. But ultimately, even if we go back, Your Honor, as I was about to say, we should first take a look at the standing argument, and the district court, as a matter of law, was incorrect in this instance in finding that the plaintiffs had established standing in its second order, and the district court was in fact correct in its first finding. The plaintiffs did not have standing in this case. The plaintiff associations don't have standing because none of the members have standing. And none of the members have standing because they have not pled a cognizable Article 3 injury under the TransUnion line of cases.
Sorry, why not? Some of the members are aliens unlawfully present in the U.S. They're the directly regulated parties.
Your Honor, they're not directly regulated parties because the harm in this case, as the TransUnion Court pointed out, the harm has to be analogous to a common law or otherwise traditional harm. And in this case, the harm, if any, is the harm of being prosecuted by another statute.
I mean, TransUnion says that when there's an intangible injury that might or might not be concrete for standing purposes. This may be insubstantial in the sense you can fill out the form in an hour, but it's very concrete. I mean, there are people who have to fill this thing out and they have to disclose more information than others, than the statute requires. That seems concrete to me.
Your Honor, going back to the TransUnion and finding an analogy there were two separate sets of plaintiffs in the TransUnion case. One set who definitely had their privacy information released from the government to a third party, and they had a cognizable, tangible harm there, versus the second group who did not have their information released and in fact had just given their information to the original recording body, and they did not have standing because there was no harm in that case to the intangible, non-concrete, non-analogous harm of simply maybe your information is out there or maybe it's not. We don't know. In this case, the only requirement that's new is, it's actually not even a new requirement. The only thing that's changed is there's now one more form in the menu of forms by which an alien can register with the government. There were, I believe.
What were they doing before?
Say that again.
I mean, when you had the old laws there and you don't fit into a particular category and you're otherwise not in the immigration line, with the courts, et cetera, what did that group of people do before in terms of officer enforcement by the government?
Your Honor, up until the rule was passed and the new form was created, that group of individuals, they had a duty to register, but they had no ability to register. And so they were essentially flying under the radar. So what's happening in this case is the government has taken section.
Would the government have taken the position that if you caught somebody who didn't fit into one of those categories, you still say they have the duty, but then there's no enforcement because they don't have the ability to register because it wasn't a form that they need to fill out. So the government would have taken that position.
That's exactly right. Now, under Section 1306, the criminal penalties attached to the willful failure to register. And there can't be a willful failure to register if there's no method by which to register. But sorry.
Okay. No, I was just going to next move on to the post promulgation comments. Is there an intention of a final rule?
Your Honor, I can't speak to that. I'm not entirely sure at this point because we're up before the court on a pre-enforcement preliminary injunction challenge. The record here is only really what we're looking at.
What's the purpose of the post comments?
Your Honor, I believe in the Federal Register, the post comments include the requirement to qualify under the Paperwork Reduction Act and the necessity to submit data to the OMB, the Office of Management and Budget, regarding the costs of filling out the form and sort of the paperwork reduction aspects of the rule, not necessarily the application or the creation of the form, because under 8 USC Section 1304. The creation of the form is essentially a mandatory requirement imposed upon the government. The Secretary is authorized and directed to prepare forms for registration.
In light of, several things going on with respect to immigration, your opposing counsel mentioned online form, English only. How do you expect to get all this information out to people for them to actually comply?
Your Honor, I agree with you that the fact that it's an online only form and it's English only, I know that my colleague on the other side has made a great point about that, but there are a number of forms that the U.S. government provides that are online only and English only. English is the language of the United States government at this point, and it's how all of our forms are created. And if the crux
Are all immigration forms
Your Honor, I can't
English
speak.
only?
I don't know if they're all English only. I do know that not every language is represented. I know there's several.
That's not what I asked.
I don't know.
I asked, are they English only?
I don't know, Your Honor.
Well, I mean, then I don't understand your point about we have lots of forms that are in English only. You're dealing with, these are forms regulating a community where by definition, a significant percentage will come in where English at best is not their native language, and they may not speak it at all. And I think it's been long recognized and in the government's interest to make immigration forms available in at least the primary languages of those who tend to enter the United States. Has that
Absolutely.
changed?
No, Your Honor.
No.
And it certainly may be the case that
Okay.
as this is only an interim rule, it may very well be the case that as this progresses, the government will provide translations and provide other opportunities. And I would also like to stress, Your Honor, that in this
But you
hypothetical.
just said, I mean, that's why I'm curious. You don't have information for us just to have asked your client about what the status of this rule is, because if you're in the process of saying, whoops, we didn't mean English only here. Whoops, we meant the criminal content of the disclosure of criminal activities to be identical to that in the statute. That lets us know what we have to decide and not decide here. So surely you can tell us, or the client or agency be willing to update us on the status of this rule.
Your Honor, certainly to the extent that it makes a difference in this court's determination, I'm happy to go back and ask my client that. And I apologize if I misspoke, indicating that there was a mistake in either going beyond the context of the statute or in saying this is English only. The bigger issue, Your Honor, is that the creation of this form and the dissemination of that form as a method of complying with the INA and the statutes, ultimately that in and of itself is not a harm, and that in and of itself does not provide standing to the plaintiffs.
It is a harm. Is it? Sorry, why isn't it a harm? If police arrest somebody and that person, they know that person doesn't understand English, and they give them Miranda warnings in English only, would that be considered consistent with the Miranda requirement?
Your Honor, that
No.
is, I don't know. So no. Okay.
No. Okay. They would not have been Mirandized.
Okay.
That's why police have it in different languages. And now you're going to say we're going to impose an obligation on penalty of criminal prosecution for you to fill out information you can't read and you can't understand.
Your Honor, under this hypothetical.
And you're going to tell me that's not a harm?
Your Honor, under this hypothetical, using the Miranda analysis, I don't know this for a fact, Your Honor, I'm not a criminal attorney, but under that same analysis, they would not have willfully failed to register under 1306 because they don't, as you said, they can't understand the form.
Oh, so the government's position is if they can't read the form, they don't have to register?
Your Honor, this is a question I haven't.
You just said that to me.
I'm saying in this
It wouldn't be
hypothetical.
willful.
Under this hypothetical, under the Miranda analysis. Which,
Right, so I'm asking, so it's the same, you just said it wouldn't be willful. There's no willfulness for Miranda, so I assumed you were transitioning to the willful requirement in the statute.
Your Honor, I believe that if there was an.
So you're not going to prosecute anybody who doesn't fill out this form because it's in English and they don't speak or understand English.
It's not that, Your Honor. I think that the prosecution, again, is in a different statutory section than the requirement
I
that
don't know
the
what that's got to
Secretary.
do with anything. If they're irreparably injured, if they face prosecution, that's a risk. People want to comply with the law. People don't want to be prosecuted. And they're left here in this rock hard place of, I can't understand this form. I don't know what to do with it, but I'm told I have to do this. And you just said, well, it won't be a problem because clearly it won't be willful noncompliance if they can't understand the form, which is a very sensible position for the government to take. I'm just making sure I understand it right.
Your Honor, I'm not in a position to speak to whether or not that is, in fact, the position that the government would take in enforcement past this point. But I do believe that the underlying issue is whether or not this rule, as a procedural rule, is somehow converted to a substantive rule merely because of the menu of language options. Presumably, any number of language options will be insufficient because there are always more.
It seems to me quite a conscious decision in the immigration context, where by practice, tradition, just realistic enforcement, the government uses multiple languages, including predominant languages. And then this rule comes along and says, no, in the immigration context, where we are seeking information from people where we can probably take judicial notice of the fact that a large percentage will not speak English or will not speak it fluently enough to maybe understand exactly what they're being asked on a form. And the government has chosen to do it in English only, unlike many, many, if not all other immigration forms. And they're doing it when they know the population will be subject to deportation or criminal prosecution if they don't fill it out. And you want to tell me that putting people in that bind is just routine paperwork obligation as opposed to a substantive judgment by the government that increases the risk of harm to people in their efforts to comply.
Your Honor, I'm not saying that that is the case. I'm simply saying that the fact that the form is English only does
What
not.
about it isn't the case? I just described to you the case. I described to you factually what has happened here. What about my description was inaccurate? I mean, assume this was an intentional decision. It's a rule. I mean, you intend what you say in your rules.
Yes, Your Honor. And again, I'm happy to provide more information about when and if additional translations are forthcoming. But the fact that the initial version of the form in the interim final rule happens to be English only does not, by in and of itself, make this into a substantive value judgment or encoding anything that entrenches on rights. It's a form that they're required to create. They're directed to create under Section 1304 to make sure that all aliens have the ability to register, as they're required to do. The duty to register.
The IRS said, we're going to issue new tax codes. They're new tax forms. They're just forms for everyone to fill out for their taxes. We're not creating tax obligations. It's just new forms in ancient biblical Greek. Notice and comment needed?
That's a good question, Your Honor. No, because it's a procedural form.
That's fantastic. Wow. Wow. We can all be criminally prosecuted for not filing our taxes unless we can find the 5 people in the United States who know how to speak ancient biblical Greek. And that's not a change in people's obligations. They're going to have to expend effort, face consequences.
Your Honor, the hypothetical and the points you're making, I think, are important points to consider. But if we step back and look at the underlying issue in this case, is the creation of the 12th form in the menu of forms that an alien can use to register with the government, is the creation of the 12th one in that list.
This is the one universal one for people who aren't seeking those other. It's not that they can't fill out those other forms. They can't fill out the visa form if they've been here already for a year. They can't, if they're not seeking asylum, they can't fill out that form. If this is the only form that applies to, in fact, millions and millions of people who haven't had a form for a long time.
That's exactly right. There are millions of people that have been unable to comply with the statutory duty to apply for registration, and the government is taking steps to fill the gap, as Judge Childs pointed out, to fill the gap between Section 1304 and the duty to create forms to register, and Section 1302, the duty to register. There has been space in that arena up until this rule was created, and the government has taken steps to close the daylight there and make sure that there's a one-to-one connection between its duty to create forms to enable everyone to register and the individual's duty to register.
Did all the other forms that were identified with respect to the INA go through the notice and comment period?
Your Honor, as we pointed out in our brief, several of them do not. At least 7 instances did not go through the notice and comment because they were merely procedural rules, as this one is. And going back to, I believe it was Judge Katsas, your question about, the impact on this. This court has previously held in the EPIC case, in the TSA EPIC case, that substantive impact, the fact that it's impacting 1 million people, does not make it automatically a substantive rule. What matters is whether it changes the rights of the individual with respect to the agency. And the rights in this
Rights and interests, rights or interests.
Sorry, yes, Your Honor, rights or interests. And the rights and interests of the individuals in this case are set forth in statute and have been for 80 years. They have a duty, the rights and interests of the individual is to register, to apply for registration. That's what the duty is. That has been the substantive right and interest for over 80 years. Nothing in this rule changes that.
Does the government intend to promulgate a final rule?
Your Honor, I assume so, based on the text of the Federal Register and the fact that they are.
Do we know anything about where that stands?
I do not, Your Honor.
Well, I guess maybe that moots out my next question, which was going to be, would this case moot out upon promulgation of a final rule?
It would, at this point, if nothing changed, Your Honor, and the preliminary injunction remains denied and the district court's subsequent ruling to stay the district court matter pending this court's determination. If nothing else changed and there was a final rule, Your Honor, that might boot this out. But given that we're in a pre-enforcement preliminary injunction context, couldn't say for certain.
One other question from me. The way this works, this new form was added to a list of forms in the regulation that will satisfy the general statutory obligation to register. Do these other forms include all of the questions on the newly promulgated one?
To the best of my knowledge, Your Honor, they all include the first 4 questions that are set forth in 1304. And then I think there are variations between them based upon the intent of each of the form. Like I suspect,
Because this form has a fair amount of content that falls within the statutorily required questions, but it also has a fair amount of new content that is perfectly fine under sub 5 of the statute, but is new content.
Your Honor, again, I agree that there are some questions on this form that have not been included in previous forms, but there are other instances, as I said, we point out in our brief, there are at least 7 other instances where the agencies have created new forms under the procedural rule. And those have different questions. The crewman's landing permit form has different questions than the visa application form because the purpose of the forms and the information sought is different. And there are going to be some subsection 5 variations there.
And as to the new material, your position is some combination of this is all procedural, like providing information to the government to facilitate enforcement of other obligations or not that burdensome.
Yes, Your Honor, it's procedural or ministerial almost based on the specific language of 1304. It also falls under this court's precedent under interpretive rules, as in the U.S. telecom case where...
Well, it can't be interpretive because you just told me there's new content being required.
Sorry, Your Honor, but in the telecom case, this court sort of said, if it's just crisply delineating the lines, and that's sort of what's happening here.
Extent of burden helps resolve the edge cases is the point.
Yes, Your Honor, that's exactly right.
Any questions?
Your Honors, thank you for the time. I appreciate it.
Thank you very much for your assistance. Okay, Ms. Lapointe, have you asked for 3 minutes for rebuttal?
Yes, thank you, Your Honors. Just wanted to start talking about the harm issues that came up in my colleague's section. We wanted to emphasize that the harm is not solely from the injury to constitutional rights that we have talked about extensively, and I understand Your Honors have some questions about. We're also talking about the harm to members such as the UFW members who submitted declarations in this case, that they simply cannot access these forms because they don't have smartphones or access to the internet and do not speak English, and therefore cannot fill out the forms and go through the registration process, placing them at direct risk of prosecution under the government scheme. We do not concede that the harm only arises, as my colleague on the other side said, from extraneous factors such as increased immigration enforcement. There are several other harms that we've identified in our papers. Second, as to the wide swath of information that the IFR is requiring beyond that which is required by the statute, as we have said previously, that implicates the need for notice and comment because it reflects a substantive value judgment that the agency is making here about the content of what to include here. But it also speaks to the arbitrary and capricious nature of this rule. And the government's choice to make it only an English form, an online-only form, and to require the disclosure of all this other information. So it goes to both aspects of the APA claim. The other rules that didn't go through notice and comment that my colleague mentioned, as we point out in our reply brief, those are instances where the government was narrowing the burden on individuals, taking off certain requirements for fingerprinting and so forth, when they did add additional burdens, those rules did go through notice and comment rulemaking. Most famously and recently in the NSEERS program after 9/11, that required members of certain nationalities and predominantly Muslim countries to register with the government, which was subsequently rescinded. Both went through the imposition of the requirements, went through notice and comment rulemaking. Now, whether or not the government is ultimately going to promulgate a final rule, the reality is that they are prosecuting people now for failure to register, and that's all that needs to be known about the government's intentions here. In addition, we did ask for a 705 stay in addition to a preliminary injunction. I just wanted to clarify that. And my colleagues' comment about the other forms not requiring all this information, just look at one of the pieces of registration evidence, which is the notice to appear in immigration court. That is a form that the government itself issues and does not require disclosure of all this other additional information. And with that, I see my time is.
Do you know if most, not all other immigration forms are in multiple languages?
Your Honor, I believe that some are, but not all of them. But those would be for immigration benefits rather than the imposition of criminal and civil liability, as this form is here, which we believe speaks to the need to have it accessible in multiple languages.
As to the issue about the criminal record in the INS under 8 U.S.C. 1304A, 4, it does state that you have to indicate your police and criminal record, if any, of such alien. So by that being vague, with respect to police or criminal record, that could include arrests. And it also doesn't limit itself to the United States. So do you think that's different than what's on this form?
We do, in the sense that the new form requires any potential crime that was committed anywhere in the world that wasn't necessarily charged in any manner or prosecuted, and therefore it goes far beyond what's required by the statute. Your Honor, with that, we would respectfully request that the district court's order be reversed and a 705 stay or preliminary injunction entered.
Thank you, counsel. Mr. Venkaswamy, I think it would be helpful to the court if you could contact your client and give us an update on the status, if any, of the rule, with the potential of whether a final rule is expected or comments are expected.
Yes, Your Honor. Just a status report on the current status.
And future plans. Yes, just to keep us updated. Thank you. All right, with that, the case is submitted. Thank you to both counsel.
Case number 25-5054. Servier Pharmaceuticals LLC appellants versus Robert F. Kennedy Jr. in his official capacity as Secretary of Health and Human Services, and Mehmet Oz in his official capacity as Administrator for the Centers for Medicare and Medicaid Services. Mr. Perdue for the appellant, Mr. Janda for the appellees.
Good morning, counsel.
Morning, Your Honors, and may it please the court. William Perdue on behalf of Servier Pharmaceuticals LLC. I'd like to reserve 3 minutes for rebuttal. Because the government has abandoned one of the 2 grounds for the decision below, this appeal comes down to a single question: whether the 2021 expenditures for Tidsovo count towards, quote, the total expenditures under Part D for any one of the specified small manufacturer drugs of Servier. The answer to that question is yes, for three independent reasons. First, Servier undisputedly manufactured Tipsovo in 2021, and the statutory analysis is product by product, not unit by unit. Second, even if the analysis were unit by unit, Servier, as the NDA holder, was legally responsible for every unit of Tipsovo that was sold after April 1, 2021. And third, even if the NDA alone were not enough, CMS never explained its exclusive reliance on labeler codes, and on remand to the agency, Servier can present evidence of packaging and quality control activities that would satisfy even the most stringent reading of the statute. I'd like to start with our argument that the analysis is product by product rather than unit by unit.
Let me just ask you one thing in a post-Loper-Bright world. Why does it matter that the government is no longer arguing for one interpretation of the statute?
I assume you're referring to
the district court actually ruled on, so we have that now decision before us.
Yes. So I assume you're asking about
the issue. Yeah.
The coverage gap discount program agreement requirement. Yes. So under Loper-Bright, it is this court's job to resolve the meaning of statutory provisions whose meaning is disputed by the parties before the court. It is not this court's job to tell parties what arguments to make to the court. And therefore, this court simply does not have a dispute before it about whether that particular provision of the statute has.
There's a different rule that under which we can affirm a judgment on any ground supported by the record. And it's a legal question. We are post Chevron, so there's no question about, if you're in the gray area, the agency can go either way. There's just pure legal question presented that's potentially dispositive and, to my judgment, looks a little bit more straightforward and cleaner than the one you all want us to address.
So I think the important point is that this is CMS's statute to enforce, and they have not put before this court any argument that we have.
District court has put it before us.
Yes, but I think there's no argument by the parties in front of this court that requirement hasn't been met. And I think for that reason, the requirement here is not just forfeited, it's affirmatively waived. And in addition, for that reason, actually affirming on that ground would violate the party presentation principle. I think the Supreme Court summarily.
That would invalidate our rule that Judge Katsas just referenced, that we can affirm on any basis preserved in the record. It wouldn't be the first time that we would do such a thing. I'm not saying we will in this case, but it wouldn't be the first time we've done that when the parties were focused elsewhere.
I think when this court does that, it is traditionally when an argument has been made below and made before this court, but the court below hasn't actually reached that issue. I can point this court to the Supreme Court's recent summary reversal just last month in Clark v. Sweeney. The Supreme Court summarily reversed the Fourth Circuit for violating the party presentation principle, for reversing granting habeas relief in a case based on arguments that
they were reversing.
The Supreme Court reversed. That's correct.
Did the Fourth Circuit reverse the trial court?
I would have to check, Your Honor.
I thought you said that they had reversed something.
The Supreme Court summarily reversed the Fourth Circuit.
I mean, but it matters because this is a rule that allows us to affirm, not
alternative grounds to affirm are a lot easier for us to reach than alternative grounds to reverse, where you are running squarely into party presentation.
And the Fourth Circuit had reversed the trial court in that case. Off point.
So I think I think we have affirmative waiver here, not just forfeiture, affirmative waiver. I get all that. And there are some prudential considerations cutting in favor of our not resting on that ground. I think
there may be others. I mean, maybe others that cut the other way.
Well, I
think this is very straightforward.
Here's another reason. If you were sort of getting towards the merits of this argument, one of our arguments for why it was incorrect for the for the district court to determine that this requirement in the statute had not been met, is that that was not the basis of CMS's decision, and therefore it violated Chenery. I think by
Doesn't
affirmative.
violate Chenery for a court to enforce a legally mandatory requirement. Chenery is all about discretionary decisions, and maybe pre-Loper-Bright close interpretive questions had an aspect of that, but not anymore.
This is
Either, covered by the CGDP agreement of such manufacturer in such year. If it means what it seems to say, you lose, period, full stop.
So I can give you yet another reason why I think this court should not affirm on that ground, which goes straight to the merits, skipping past Chenery, which I do think is a problem.
But let's just finish up on preservation. I'm interested in the merits, obviously, but just give me all you have on preservation, and then
I'm sorry, on preservation of.
on prudential considerations, why you think we should not reach.
So I think there are three. That it's affirmative waiver. It's affirmative waiver, not forfeiture. It's the party presentation principle, and it's the fact that this was not the basis of CMS's denial. So it would violate Chenery. If you go to the merits of this CGTP agreement requirement, I think both parties are correct on the merits here. So if you go back to 2021, the CGTP statute required Servier to include Tibsovo on its coverage gap discount program agreement. But CMS at the time prohibited Servier from doing that. In its guidance under the coverage gap discount program agreement, CMS told parties like Servier to leave Tibsovo on the old manufacturer's coverage gap discount program agreement and just work things out between themselves. That's what CMS told us to do. And so that's what we did do. Now, today, if CMS had followed the district court's interpretation of the statute, CMS would be telling Servier that actually Servier was violating the CGTP statute back in 2021. And as a result, it's also violating this statute now. And that kind of inconsistency is quintessentially arbitrary. If there are no further questions on the coverage gap discount program.
That sounds a little bit like an argument that the government's prior misinterpretation of a legal duty immunizes violations going forward.
I wouldn't characterize it that way. I think an important aspect of the way that CMS implemented the CGTP program back in 2021 is that it was implemented through agreements. So the requirement was that Servier had to include Tibsovo on an agreement between Servier and HHS. Servier can't do that unilaterally, obviously. It's an agreement. They can only put things on the agreement that HHS will agree to. And HHS had guidance that said, we will not agree to that. We want you to keep it on the other agreement and work things out between yourselves. And so that's what we did.
The agreements are filed roughly a year out. They're filed before the year. The 2021 agreement would have been filed before January 1, 2021.
I don't recall whether the agreements are annual or updated, or they're just ongoing. So I'm not sure.
What I was going to ask, maybe you don't know, are they, once they're filed, is there some mechanism for mid-year amendments?
There is certainly a mechanism for adding new labeler codes to an existing agreement, but you can only add full labeler codes. You can't add an individual drug.
The labeler code identifying the manufacturer.
Right. So we could have put all
product. Right.
We could have put all of Agios's products on Servier's CGTP agreement in 2021, but that's not what the transaction was between Servier and Agios. We only bought the one drug, and so we couldn't put only the one drug that we bought onto Servier's.
You had bought the entire company. You could have amended the agreement to reflect all the new drugs of that company, and that would have solved this aspect of your problem.
Yes, we could have put the whole labeler code on, but we could not put on the individual drug that we bought. That was impossible. And impossible requirement. Sorry.
And so, no, so I'm interrupting you, sorry, but the basic idea is kind of the greater power to amend mid-year as to all the products of an acquired company suggests a lesser power to do an amendment just for the one drug.
It's not a greater includes the lesser sort of situation, because what you put the mechanism for the amendment is you put the labeler code on the agreement, and the labeler code includes all of the drugs for that labeler, for that manufacturer. Or
The greater power to add a labeler code suggests a lesser power to add the drug code. This is a friendly line.
Yes, if you're asking whether CMS could have administered the program drug by drug so that we could have done this, yes, CMS HHS absolutely could have done that, but they didn't. And there was nothing we could do about that unilaterally. We were at HHS and CMS's mercy at that time. If I'll now turn to the arguments that the parties have actually disputed before the court, I want to start with our argument that the analysis under the statute is product by product and not unit by unit.
Can I ask a fact question for you?
Yes, please.
This labeler code, where does it appear? Is it on the pill? Is it on the bottle? Is it on the pallet? Is it?
It is not required to appear, but it is the FDA's regulations recommend that it appear on the box.
So if I buy an individual box of Tylenol or something, it'll have a labeler code on it?
It's recommended by FDA that it appear there, and it most likely would.
Okay. Otherwise, it is simply a reporting form. It's used for reporting at a minimum.
It's a record keeping
beneficiaries.
It's a record keeping mechanism for FDA to keep track of different drugs.
And I thought like sales of drugs, at least to Part D beneficiaries, had to be reported to as well.
Yes. So there's
through the labeler code.
Yes. So there's a mechanism called PDE data under Medicare Part D, in which the insurance company, after the fact, submits a record to CMS of all the transactions that have happened. It includes a lot of different pieces of information. What the drug was, what the price was, the copay, other information, and among the pieces of information there is the labeler code.
It's who manufactured the drug the Part D beneficiary received.
It's not actually the manufacturer. It's just the labeler code.
The labeler code identifies the manufacturer. You said that already. That's one of the things the labeler code does, is identify the manufacturer.
It can identify that. If I said that, I misspoke. The labeler code can identify the manufacturer, but that's not the only person it can indicate. It can indicate the repacker, the relabeler, and most relevant here, it can indicate the private label distributor.
Sale could be made without knowing who manufactured the pill. That seems really probably in case there's any sort of adulteration or contamination processes.
It's not that it's
to be identifying the manufacturer in this process.
It's not that it's not known. It's just that number that is on the box can refer to entities that performed a number of different roles in the manufacturing process. It can include the manufacturer, but it could be the relabeler, it could be the repacker, or it could be.
What would identify the manufacturer?
There's no.
They don't know they've got to be tracing who manufactured a drug for.
It's not the labeler code that necessarily.
What does to do it?
I mean, our position would be that the NDA indicates who is really the manufacturer.
When the insurance company is providing information to Medicare or CMS about sales to Part D beneficiaries, it identifies the manufacturer as part of it.
It does not identify the manufacturer. It identifies the labeler code, and the labeler code may indicate the manufacturer, but it may not.
Okay, and then what if there's something wrong with the pills? How do they find who manufactured them? They know who got it.
That's an FDA enforcement issue, and they have investigatory powers. They can look at who held the NDA, but they don't. The labeler code is not how they determine who is the manufacturer, because we quote and cite the FDA's NDC or National Drug Code regulations in our briefs, and it is clear as day express in those regulations that the labeler code can indicate entities that are not the manufacturer.
Where is that? Which regulation is that?
I don't have the site in front at my
Maybe
fingertips.
rebuttal.
I'll give it to you on rebuttal if that's all right.
But the other thing is that 21 CFR Section 207.33C requires that if you're engaging in manufacturing, you're to update that label code within 30 days. So why wouldn't that be a necessary requirement and that you couldn't wait 6 months to do that?
I'm sorry, I'm not following the
You're
question.
required to update the labeler code information within the 30 days. You didn't do so here. And then now you're seeking credit basically for that labeler code, with respect to the sales.
So I'm not sure. I'm not sure what the regulatory site you provided is referring to and what kind of update you're referring to. I can try to look at that on rebuttal. But the critical point, I think, for the court to understand is the labeler code does not necessarily indicate the manufacturer. It simply doesn't. And I think that's the district court cited and quoted.
What does it indicate? What's the point of the labeler code?
It indicates an entity that engaged in one of several possible activities with respect to that drug. It can indicate that it was the manufacturer. It can also indicate that it's the relabeler or the repacker or the private label distributor. And actually, in this case, the two labels we're talking about here, the Agios's label from 2021 and Servier's label from 2022, those labels indicate that Agios and Servier, respectively, were the private label distributor of this drug. And I think it's important for the court to remember that the manufacturing definition in the statute carves out distributors. So an entity that is a mere distributor is not a manufacturer under the statute. If I can go back to our main statutory argument, which I think sidesteps a lot of these issues, that is our argument that the analysis is product by product, not unit by unit. The key statutory language,
Which is an odd framing. I mean, you have some nuggets and there are aspects of this statute that one can read to support that, but it just seems like a very odd framing in the context where this is all about items that are paid for by Medicare or CMS. And they pay for individual increments of this drug. They don't pay for the product.
yes, everyone agrees here that to calculate the relevant total expenditures here, you need to aggregate expenditures for multiple Tibsovo units. The question before the court is, do you aggregate some Tibsovo units, the ones with the right labeler code on them, or do you aggregate all of them? And our interpretation of the statute is simple. Total expenditures under...
Suppose for the sake of argument, just to untangle the statutory argument from the arbitrary and capricious argument, just suppose for purposes of the question, we think the labeler code just means the manufacturer.
So
I know you dispute that, but
yes, and I don't think that the government actually disputes that either. The government's view is that the labeler code is a proxy for the quote actual manufacturer.
okay, fair enough. Suppose it's a reasonable proxy. Or
So-
forget about the code and let's just talk about the substantive law.
Okay, I believe there are two questions there, so I'll try to answer them in turn. So even if you think that the labeler code is a reasonable proxy for the actual manufacturer, it is not the only possible proxy. Another one, for example, would be who holds the NDA. That is in fact how CMS itself today.
Sliding back into the arbitrary and capricious argument.
Yes, I thought that's where you were heading.
I want to stay on the contrary to law point for now.
Okay, so our point is simply that our interpretation of the statute is simply that the total expenditures under Part B for one of the specified small manufacturer drugs of the manufacturer. And I think everyone agrees that that refers to a product, not a unit. So the total expenditures for that product means all of the expenditures for that product. Now, Judge Katsas, you suggested that was might have some counterintuitive results. I would welcome the opportunity to explain to you why we think that actually makes sense in light of the statutory purpose.
Okay, so the counterintuitive ones are the December 31st acquisition where 99% of the stuff is manufactured and sold by the predecessor company.
Absolutely.
And you want attribution of all of that.
Yes. So I think the important thing to remember is that the purpose of this statute, the purpose of this specified small manufacturer definition is to identify a particular kind of manufacturer, a small manufacturer with a non-diversified Part D product portfolio. When you're evaluating the diversity of a company's product portfolio, it is quite reasonable to do that analysis product by product. Now, we can talk about the edge cases, but just a product by product approach is certainly a reasonable way for Congress to approach this question overall. And go specifically to this hypo. Yes, under a product by product approach, under your hypo, all expenditures for the whole year for that product count towards the 80% threshold. That result may be counterintuitive, but it doesn't undermine our product by product reading for a couple of reasons. First, I think at least part of the idea behind that hypothetical is that it seems to allow a manufacturer to game the system in some way. But it's important to remember that this is a 2022 statute that is keyed to events that occurred beforehand in 2021. So there is absolutely no possibility of gamesmanship here. Congress, by the way it designed the statute, eliminated that possibility. And in fact, for that reason, we know sitting here today that that hypo that you posited won't ever actually happen. The government already knows the entire universe of cases to which this statute will ever apply, and it has already made virtually all of the determinations that this statute will ever require. I do think even if this scenario could happen, it still makes sense.
It's a fair point about gamesmanship, but you still have a statutory structure that seems to use events in the past as a proxy for, a prospective assessment of, are you small enough and are you non-diversified enough?
I couldn't agree more. And I think that's why the product by product approach actually does make sense, even in the hypothetical you gave, the December 31st acquisition. So Congress was trying to determine in 2022 whether identify manufacturers that are small and non-diversified. It does that by looking back to 2021. There's nothing magic about 2021. It's just the last full calendar year on record. So if during 2021, you have a company that has one product that dwarfs the sales of all of its other products, odds are that that product is going to dominate their sales going forward into 2022 as well, even if they only made one unit. And I think actually, if you've only focused on that one unit, you would really get a misleading picture of the diversity of that company's product portfolio. And I think that's actually exactly what happened here. Servier acquired this product in April. It began manufacturing the product. It was earning revenue from this product because of a quirk of how FDA allows labeler code. Allows a manufacturer like Servier to use the old manufacturer's labeler code during a transition period. The labeler code wasn't used during 2021, but going into the sales from that product during 2021 dwarfed everything else they were doing, and going forward into 2022 and forward when these discounts are actually going to kick in, Tipsovo again was still dominating the entire portfolio. So another way to put it, Judge Katsas, would be that the government is suggesting with that hypothetical that our rule is over-inclusive. I think their rule is under-inclusive because it doesn't account for this kind of situation where we're exactly who this statute was designed for. Servier was small, that's undisputed. That's the specified manufacturer part of the statute. And we clearly had a non-diversified product portfolio going into 2022. It's exactly who Congress
Clearly
wanted.
did not manufacture, as in, if you think of manufacturers, is what was sold. It was made and sold that year to Part D beneficiaries, which is also what the statutory language closely focuses on. What did you make that you sold to Part D beneficiaries? And my understanding from the record is that was made and sold to Part D beneficiaries in 2021 was, I don't know how to say, Agios's pre-existing stock.
So
100% pre-existing stock, which was not in any sense manufactured by, it was manufactured, all done being manufactured before the agreement was inked. And it was then sold to Part D beneficiaries. And what's wrong about that?
So if the analysis is product by product, the only question for this court is, did Servier manufacture the product? And we
But
undisputedly
then you
did.
want to say just because we all two entities here, I'm assuming Agios as well, were small and non-diversified. One of them actually manufactured 100% of the pills that were sold to Part D beneficiaries in 2021. And one came in later to own the rights to those pills, but did not manufacture them. It just said, well, I've got this pile of pills over here. Let's let it out in the market, so I'll make some money off of it.
So if the analysis is product by product, that doesn't matter. But I take it you're positing that you
I'm
would
just wondering
interpret.
why Congress would, what do you mean? I'm not sure what you mean product by product. The product had to be, by the statutory terms, had to be what was sold, what was manufactured and sold to Part D beneficiaries in 2021. Those are other statutory requirements. That's what Congress was focused on textually. And if it's pre-existing stock, you didn't manufacture something that's already made.
So I think that you're pointing to the manufacturer language in the statute, if I understand your question. And I think that the important textual point on that is that the of the manufacturer comes after the words one of the specified small manufacturer drugs. I think everyone agrees that that phrase refers to a product as a whole. And just adding the prepositional phrase of the manufacturer after it does not mean that that one of the specified small manufacturer drugs is some subset of a product. It's still a whole product. It's just a particular kind of product, one that was made by the manufacturer during the year. And Servier undisputedly did make Tibsovo during 2021. I think that the broader question you're getting at, I think goes to
Tibsovo. You did not make it, physically make it.
That is
And
I'm sorry.
sell it to Part D beneficiaries in 2021. That's the record before us.
Yes, we made units, and those units were not sold until 2022.
Right, the contract is about this year, particular year.
And I think the point, Your Honor, is simply that that timing quirk doesn't matter if the analysis is product by product. But I see that you may not agree with me on that, so let me explain why we can still win even if you do disagree with me on that. So I have two answers for you about what we actually did in 2021. One is the actual story of what we did, which is what we would show to the agency on remand if given an opportunity, and the other is what we did. What we already showed the agency based on holding the NDA. So if you're looking at what we actually did and what we'll show on remand if we have an opportunity, we can give CMS the lot number for Tibsovo that was actually dispensed to Part D patients in December of 2021. And then if you trace the manufacturing process for that lot backwards in time, on April 1, 2021, those tablets had been physically pressed, but they weren't labeled and packaged and ready for sale. So what happened was that after April 1st, Servier's contractor put those tablets in bottles, labeled and packaged the bottles in boxes, and put serial numbers on the boxes. And then later in the year, in 2021, units from that lot were dispensed to Part D patients. So we can draw every single link in that chain. So that is what actually happened and what we can show on remand.
The manufacturer is defined, right? And you have to manufacture, and you have to be a manufacturer. And that means that you were engaged in the production. You weren't. Preparation, you weren't. The propagation, you weren't. The compounding, you weren't. The conversion, you weren't. And the processing, you weren't.
I think we were involved in the, I left out in the story that I just told, there was one piece I left out, which is that Servier personnel reviewed the quality control documentation from the contractor and affirmatively signed.
That was not before the district court.
Correct. That's not
Okay,
before the
then
district court.
That's not before us either.
Correct. I'm trying to answer your question as to what we can show on remand. So if there's a remand, this is what we can show.
Okay, I'm just trying. Whatever you can show on remand is not really of much interest to us because you have to show to get a remand that you are a manufacturer and you made no record,
So
even assuming that quality control comes, which isn't on this list. But so what did you did not show in this record that you met the statutory definition of manufacturer. You showed that you owned the pills. And a lot of your briefing is clear. You owned the NDA, you owned the pills. You owned the rights for those pills. I get all of that, but owning is not the same as manufacturing. And this is a very specialized definition here that really is focused on, it goes on with, use of chemical synthesis or extraction and chemical synthesis. I mean, it's really talking about the process of making these pills. And am I right that every single pill that was sold in 2021 to a Part D beneficiary was stock that pre-existed the inking of your agreement?
the
Yeah.
pills were physically
The
pressed.
stock-
Yes.
Yes. yes.
If you're asking about what the pill,
Nothing was manufactured after you took over the rights to this drug in 2021 that went to a Part D beneficiary that year.
depends on what you mean by manufacturing, but
I mean, the statutory definition. No, the statutory, it's got to be making it in some way. And if everything that was sold was already made, then you didn't make it.
so let me explain why I think that's not correct. So the tablets were physically pressed before April 1. So that factual premise of your question is correct. We don't dispute that. As the NDA holder, we were legally responsible. And I think there's a very important point here, which is that the government's only response to the argument that the NDA is insufficient is that we didn't preserve it. So this court does not need to get into these merits questions at all. So if we preserve that argument, that there's no further dispute about the merits here. But you asked about the merits, so I want to answer your
I
question.
don't think they agree that just holding the NDA makes you the manufacturer.
They
I mean,
They
they can
don't-
tell
they
me if
don't-
I've got this wrong, but
don't affirmatively agree, but they do not articulate any argument in their brief about why that's wrong.
because it wasn't, in their view, it wasn't raised below.
That's their-
That doesn't mean
that's-
anything. But there's nothing in the statutory language that cares about who has legal obligations with respect to. It just doesn't, it's not the statutory language used here. They're focused on the manufacturer.
And so the reason, again, this gets to the merits. So this is only if you reach the merits and even though the government hasn't argued it, but reaching the merits of this NDA argument, the point is the following. Servier, as the NDA holder, was legally responsible for the labeling, the quality control, and the manufacturing of every unit that was sold after April 1. So for example, if FDA had determined that the label on units sold after April 1 was missing a warning, for example.
I get all of that. You owned all legal consequences. That's not what they're talking about in the what is your best language to say that the definition of manufacturer includes someone who took pre-existing stock, did not make a pill,
So
but had legal responsibility for it? Which word do you put legal responsibility into?
I think we have legal responsibility for all of those words. And here's
There was no more production.
let me give
No
you
more preparation. There's no more propagation. There was no more compounding. There was no more conversion, and there was no more processing as to that pre-existing stock.
So what I think Your Honor is suggesting is some kind of act omission distinction. And there are many areas of the law
I
where,
don't think I'm suggesting that at all. But I'm talking, tell me which word.
so
Which word is it?
the words in the statute include either directly or indirectly, which I think includes adopting actions taken by others. And I think it's important to, this is a situation where it makes sense to hold.
Which action? I'll take your indirectly. Which one did you, because you had all pre-existing stock.
So
Did you
I think-
produce it?
Yes,
If it already was produced, how did you produce it?
because we were responsible for it. And here's how.
Responsible for isn't the same as production. I understand the NDA comes with legal obligations to you, right? If something had been got contaminated in your storage process, you're going to be held responsible for that. Or in your trucking process, you're going to be held responsible for that. That means you're distributing and you're legally responsible for distribution and maintaining quality control during distribution. That does not make you the manufacturer.
So this is, CMS itself disagrees with you on that point, Your Honor. This is not a novel argument. So in 2 other drug pricing programs, CMS itself today implements a materially identical manufacturer definition to say that it includes the NDA holder. That's the Medicaid Drug Rebate Program and the Drug Price Negotiation Program. So
I understand there's other statutory, but that just shows that the language they've used here is very, very particularized.
no, it's materially identical language, absolutely identical. You can look at the statutes; there's no difference between them. And in the Medicaid, in the Drug Price Negotiation Program, that when they were putting out their guidance on that program, a commenter made exactly this point to CMS. They said, you should use the labeler code, not the NDA holder. And CMS said, no, that's wrong. We disagree. We are going to treat the NDA holder as the manufacturer because that fits with, quote, the FDA regulatory framework. So that
Statute.
for an absolutely identical statute that is a distinct statute, yes, but the manufacturer definition is identical. It's the
Some
same.
of the other ones include things like labeling, packaging, distributing.
It's not the drug price negotiation program. The manufacturing definition is exactly the same, Your Honor. If I could pull back from the merits for a moment.
And then the use of that word manufacturer in the statute and the other statutory provisions, the operative provisions.
It uses the word manufacturer, and the definition of the word manufacturer, which has those six activities, it's exactly the same in the drug price negotiation program as it is in this statute here. And CMS today says that means NDA holder in that program.
That statute. Okay.
So you don't think that updating the labeler code has any effect on your arguments when that was a requirement as well?
I'm not fully following your question, Your Honor. I apologize.
Well, it says that you're supposed to update your labeling code, once this agreement changed hands.
I see what you're saying. Yes. So the reason we did not label this inventory that we were selling in 2021 with our labeler code is for a couple of reasons. First, this is common industry practice. In addition, it would have been wasteful to get rid of that stock. In addition, it would have created a break in the supply chain, a break in the supply of this life-saving medicine to patients to have to relabel everything. And importantly, FDA has a long-standing policy that allows manufacturers in precisely this circumstance to use the old labeling during a transition period. That is noted in our recalculation request. That's at JA 112 footnote 3. It doesn't use the word FDA, but that's what that footnote is referring to, is this longstanding FDA policy that allows manufacturers to use the old labeling in these circumstances. So that's why we did it, because we were permitted to do so.
But they don't suggest that they by that reason, because they're not allowing that rationale to go forward.
Yes, and there was I think that goes to our arbitrary and capricious argument, if I'm understanding your question. And so there was the denial includes no explanation whatsoever for why CMS was attributing expenditures of Tibsovo to manufacturers based solely on the labeler code. The government's brief tries to fill in that gap in reasoning, but none of their explanations appear in the denial itself. The denial is at JA 119 to 120, and it's just not in there. All the denial says is the guidance and the methodology say to use labeler codes, so we're going to use labeler codes. We told them at the time, we don't think that makes sense here. We're the NDA holder. You should consider using the NDA. And there is no explanation whatsoever for why they didn't do that. And again, this is not an off-the-wall novel idea to use the NDA rather than the labeler code. It's exactly what CMS itself does today in 2 other drug pricing programs. So at a very minimum, I think you need to set the denial aside and send it back for a new explanation for why they chose this particular proxy, the labeler code, and not the NDA. If I could, because there were so many questions about the merits of the NDA argument, I do want to go, I see that I'm far over my time, but I want to go to preservation, but only if it's helpful to the court.
Preservation of the
NDA argument.
Yeah, okay. I think we have your briefing on that.
Okay,
But we will give you some time on rebuttal as well.
thank you very much.
Yeah.
Morning, Your Honors, and may it please the court, Sean Janda for the federal government. I intended to start this morning with the lead statutory argument pressed by Servier, and in the absence of any contrary direction from the court, I'm happy to start there. I think the easiest way to understand why that argument's wrong is just to substitute the definition of specified small manufacturer drugs for those words in the relevant provision, which the district court did at JA 224 to 25. We did at page 26 of our brief. When you make that substitution, the statute then directs CMS to focus on, quote, the total expenditures under Part D for any one of the drugs that is produced, prepared, propagated, compounded, converted, or processed by the manufacturer. And I think once you make that substitution, it becomes clear, again, that CMS is acting fully consistent with the statutory text in focusing on who actually produced, prepared, propagated, compounded, converted, or processed the drugs for which there are Part D expenditures. And I think once you agree with us that that's the right focus, there's just nothing, I think, in the record here.
Where that gets us, doesn't that put us right back in the question of what do you mean by produced? What do you mean by prepared? If we had to, we are now the ones that are in charge. We own it and we're in charge of it.
So I don't think so, Your Honor. I mean, I think you could imagine an argument if they had made an argument in front of the agency or in front of the district court that says, we did this thing and that thing and the other thing that count as one of these words. They didn't make that argument. And I don't want to get ahead of the agency. If they had made that argument to the agency, I don't know if the agency would have thought that doing the quality control or doing the labeling or packaging the product, which they now say they did, would have counted as one of those words. I just don't know. And so I think sort of once you accept that we're right about the statutory argument, at least as to the one legal argument that I think they have consistently pressed, sort of starting in the agency and through this court, which is that it doesn't matter if they actually manufactured any of the units sold to beneficiaries in 2021. It makes clear they're wrong about that. And then for everything else, I mean, all I think we're in a position to say is that on the record before the agency, we certainly didn't see anything that suggested that they produced, prepared, propagated, et cetera, the actual units sold in 2021. And I think they now think they could make that showing, but they certainly didn't do it before the agency. And then, I mean, the other thing I'll just sort of say briefly is I think in addition to that kind of clear textual argument, just every feature of the statute focuses on the manufacturer sort of over and over again. It doesn't sort of talk about it. We've been very easy to talk about the distributor, the seller, the NDA holder. And it doesn't do that. I mean, it really focuses on the physical process of manufacturing the drugs for which there are expenditures in 2021. And that's where the agency is focused. And again, I think that's just where the administrative submission sort of starting off falls short.
The labeler code is not defined in 42 USC 1395. But you all use that as a way of essentially being a determinative factor as to who's the manufacturer is. So how do you explain that?
Yeah, so the labeler code is given by the FDA to manufacturers. And I think the expectation is that the manufacturer or in some circumstances, a repackager or relabeler puts their labeler code on the product. And so what the guidance that CMS applied here says is that, the labeler code is what the manufacturer puts on the product. We're going to use that. I mean, at least as a first pass, I think, again, if
an industry understood term in that regard, that the labeler code is for the manufacturer.
Yes, so labeler codes are given, I think we cite the statute, actually the FDA, not CMS, but the FDA provides labeler codes to manufacturers, I think packagers, labelers, And then the labeler code is going to identify the manufacturer or potentially the repackager, the relabeler. And I think if we had a circumstance where someone came in and said, we actually manufactured this stock, it was then repackaged, and the repackager sort of took off our labeler code and put on their labeler code, but you should give us credit for the stock because we actually manufactured it. The agency might well sort of take a look at that evidence and determine that it's appropriate to disregard.
And then how do you respond to your opposing counsel's arguments with respect to the NDA as opposed to the labeler code?
I think
Them.
there's a couple things. I think just as a legal matter, again, we've been very easy to write the statute to focus on the NDA holder or the owner or the seller, and it doesn't do that. It focuses very much on the physical process of producing, which I think the guidance reflects CMS's determination that the best evidence, or at least sort of the starting point of who did the actual manufacturing is going to be the labeler code. And again, if they come in, they had said, we did A, B, C, D, and E physical things to this product, even though it has someone else's labeler code on it, the agency may well have been willing to engage with that evidence and disregard the labeler code. But that just was not a thing that was ever presented to the agency in this case.
Can I take you back to your plain language argument? So I'm trying to do on the fly what you suggested, which is plug in the special small manufacturer drug definition into the legally operative text. And I'm going to elide over some things that seem to me clearly immaterial. But so when I do that, I get total Part B expenditures for any drug manufactured by the manufacturer. Fair summary?
I think the first part is right for any one of the drugs manufactured by the manufacturer.
Why? I came at this with a strong intuition that you have to be right, but just reading those words, and the Tipsovo was manufactured by the manufacturer in 2021. And then the statute says, what are the total expenditures, total Part D expenditures for Tipsovo? And that seems to not, just those words do not seem to foreclose your friend's interpretation.
Yeah, so even if you think that they're not sort of foreclosed by the statutory text, I think just every relevant indication of the statute focuses in on sort of particular expenditures for particular drug stock manufactured by a particular entity. And it starts with the expenditures, which I think as Judge Millett observed earlier, that Medicare doesn't make expenditures for a drug line. It doesn't buy Tipsovo as a product as a whole. It makes expenditures for particular dispensing of Tipsovo to particular beneficiaries. And we really have to focus in CMS's view on those expenditures. Second, I think
yes, in the sense you have to focus in on Medicare expenditures on Tipsovo, like no question. You can't focus on, Blue Cross expenditure on Tipsovo, but that doesn't answer the question, one level more granular on sort of, is it Medicare expenditures on Tipsovo for the pills that, whether the predecessor manufacturer or the successor manufacturer.
Right. I think that sort of the frame of the expenditures puts us talking about particular stock rather than talking about the drug line as a whole. But even if that doesn't do it for you, I think, again, we have sort of one long definition here that's all linked together. As Judge Moss observed, I think Tipsovo sort of tries to break out, Servier tries to break out the different pieces of what is really a connected phrase and tries to take them all in isolation, which is not really how the statute reads. I think in addition, as there earlier,
how are they trying to do that? I thought they just have a, you heard it, a holistic theory, right? This is about projecting what's going to happen in 2022 and, who owns the drug on This is not a crazy way. Their reading of the statute is not a crazy way to assess who will be a small and non-diversified manufacturer in 2022 based on, what's happened in 2021.
I mean, I think it does lead to a bunch of anomalies, which I'm happy to talk about. And I think the one that they have sort of managed to explain why they think it's not so anomalous is like maybe the only one where they could say that. But just focusing on, but before I get to that, I think
the December 31st hypothetical.
Right. And I understand the response to that, but you can flip
That
the
seemed to be
hypothetical.
very anomalous, but the answer, your friend's answer resonated a little bit.
I mean, fair enough. But I think if you flip the hypothetical and make it a single pill on January 1st, and then they divest the line, then you don't have the answer that, well, it will tell you what's going to happen in 2022 because it's right before 2022. But I think it would be the exact same thing. I think they would say if you manufacture a single pill on January 1st, that's then sold to a Part D beneficiary, you are entitled to all of the expenditures for Tipsovo for that pill or for that drug for the year, even though at the end of the year you don't have the line anymore. It also, I mean, the other thing I would say is they also would apply in circumstance where throughout the whole year you have multiple manufacturers manufacturing the same drug through licensing agreements or otherwise. And I think again, there's CMS's view, each manufacturer would presumably put their own labeler code on the stock that they manufactured and would get credit for those expenditures. Again, under Servier's view, I think each manufacturer would be entitled to the total Part D expenditures of all the manufacturers making that same drug, which again, it doesn't, if you're trying to think about who's small and non-diversified, doesn't map onto the actual manufacturing activities and the drug portfolios. And so I think, again, just CMS's high-level view of how this is supposed to work is just that you match up who actually manufactured the pills with a particular drug manufacturer. You aggregate those together, and then that gives you a sense of the drug manufacturer's both size and diversified or non-diversified status, and moving away from the actual manufacturing of the drugs, I think would introduce those anomalies.
The way so assume I'm a Part D beneficiary and I get some Tipsovo, my insurance company must pay for it, or the insurance company intermediary works it. How do you know? I assume it's a labeler code, or no?
So I think if you were trying to figure out who manufactured it, if that's your question.
That's what you have to do. You have to know, you line up all the Part D beneficiaries and all their Tipsovo, right? You figure out who made it.
Right.
Then you go back and see if it's diversified or not.
Right. And so the first thing that you do and the first thing that CMS does is just aggregate all the data. When there's a dispensing of the drug, the sort of pharmacy or whatever fills out a form that includes the labeler code that gets sent back to CMS. And so CMS just sort of starts by pulling the labeler codes.
And I assume that's because there's an assumption that the labeler code, you rely on that because that generally identifies the manufacturer?
Correct. And again, as I said, I don't think Servier disputes that in the mine run of cases, the labeler code is going to accurately identify who actually manufactured the product. If there were an odd circumstance where that weren't true, that the agency, I think, would have to confront that. I'm aware of, it's not in the record, but I'm aware of at least one manufacturer that came to CMS with exactly that sort of information where they said, though it was someone else's labeler code.
An unusual situation, but
we did the thing and CMS looked at the evidence they submitted and ultimately determined that it should disregard the labeler code and attribute them.
Fine, but you rely on the labeler code. Is the pharmacist reporting who owns the NDA?
I'm not sure what all information is in the prescription drug event records that get sent back to CMS. I know the labeler code is there. I just don't know if the NDA holder, unless it's reported on the package, I would assume it would be a thing that they wouldn't report, but I don't want to say that for certain because I have not seen what these event records look like.
Right, but it sounds like the way the system is, the way it's set up is, okay, these drugs are getting dispensed. I got to know who manufactured it for purposes of doing this analysis, maybe for other reasons too, but certainly for purposes of this analysis, I get the information based on the labeler code. And the labeler code comes up to me and then we can do the math, figure out who qualifies as the wording of this is a specified small manufacturer.
Correct. And that's sort of how CMS has done it. And again, I think there's nothing in the record here that I think would include CMS into the idea that the labeler code here did not actually identify who had produced, propagated, et cetera, the pills that were being sold in 2021.
Can I ask you about the alternative theory? Just seems very clear to me that Cipsivo was not covered by the CGDP agreement of Servier for 2021. Why doesn't that resolve this appeal?
Right. So I think the problem that we have with that is that my understanding is there is a very long historical practice of CMS that allows one manufacturer to sort of piggyback on another manufacturer's agreement, which it helps ensure, I think, sort of uninterrupted Part D coverage of the drugs when drugs sort of change hands. And so CMS's understanding has been that in a circumstance where one manufacturer is piggybacking on a different manufacturer's agreement, that you sort of treat that piggybacking as the agreement of the piggybacking manufacturer. And so CMS would not, my understanding is, would not have, in this circumstance or another circumstance, refused to attribute expenditures to Servier or to another drug manufacturer because they were piggybacking rather than listing the code under the drug on their own agreement.
So it would be just on the facts of this case, April 1 sale, and then by December 1, pills manufactured by Servier are paid for by Medicare, and you want to count those pills.
Right. So for these purposes,
You don't want the lack of the CGDP agreement to disable that attribution.
I think it is that attribution in this statutory context, my very vague understanding.
Just trying to figure out what's the difference between the two theories? Like, where does the difference matter?
So I think it matters for purposes of this particular statutory determination in exactly that context. My understanding is that
The one I just said.
correct, where it's still on, but they've actually manufactured the pills. Just to be clear, my understanding from the agency is that that there is a fear that it would destabilize if that were read to not permit this sort of look through or attribution of the one manufacturer on the other agreement, that may destabilize other circumstances where the agency has sort of long treated or long permitted that sort of piggybacking, which ensures, again, sort of Part D coverage of drugs uninterrupted in this circumstance where they change manufacturers.
And what's the government's response to Servier's argument about it's normal business not to immediately change the label?
So my understanding, Your Honor, I'm not sure about the regulation that you were referencing. My understanding is that the CMS or FDA, it's probably FDA actually, would not have a problem or does not have a problem with sort of already manufactured pills having the labeler code of they need to manufacture them, even if they are then bought as pre-existing stock and sold in these circumstances. There's no requirement that the labeler code be updated to reflect a new sort of distributor or seller, which again, I think also sort of underscores that the label or code is added, I think, generally at the time the manufacturing happens. And so it's a quite good proxy for the manufacturer rather than for the seller, the distributor, pharmacy. I mean, that all people sort of further down in the chain, which are not who we think the statute focuses
But you're
on.
looking to the labeler code to determine the manufacturer in some instances.
Sorry, I'm saying, I think my understanding is that because the labeler code is often put on when the product is manufactured, it is a quite good proxy for the actual manufacturer rather than for the distributor, the pharmacy, the sort of seller further down in the supply chain.
Can you explain to me the piggybacking one more time? Because the way it's described in your brief, it sounds like it's the inverse of this case. So tell me, define piggyback for me.
So my understanding, which comes with all of the usual caveats of my understanding of CMS, is that in a circumstance like where one drug manufacturer has a product on their program agreement or had a product on the program agreement, and then they sell the product line to another manufacturer, as happened here, CMS permits the acquiring manufacturer to piggyback on the selling manufacturer's agreement for the purposes of of that drug. And the reason for that is that it ensures that there's uninterrupted Part D coverage because sort of inclusion on a program agreement is a requirement for Part D coverage. And so that there is a desire not to have an interruption in coverage by having to sort of transfer or amend agreements.
But what your footnote says is, thus, if Part D had incurred expenditures, and I could just be misunderstanding, but in 2021, for Tibsovo, that was covered by Agios's agreement, but that Servier had manufactured under its own labeler code, you would go ahead and attribute this to Servier. But that's not what happened here. Right. Servier didn't manufacture anything under its own labeler code. So your example doesn't fit this case. It fits the opposite.
Right. Sorry. So what we're saying is that if Servier had actually manufactured and produced under its own labeler code, CMS would not treat the fact that
they don't fall within this piggybacking exception.
We do not think that they fall within
The piggyback exception,
statutory
they didn't
definition.
manufacture. No, they don't fit within this, your piggybacking policy.
I think they until they listed on their own agreement, they were piggybacking on Agios's agreement,
But
which is not just.
It is that piggybacking would occur, right? Because you already have Tibsovo covered by Agios's agreement. They got the agreement. But if Servier had manufactured under its own label code, then Servier could piggyback on the agreement. But that's not what happened here in your view, correct?
Correct. I mean,
So then they can't fall within your piggyback exception.
So this may have been.
So why aren't we going back with the statute?
So this may be an imprecision in the way we drafted. My understanding.
Well,
is,
this can't be, because I mean, you talk about Servier manufacturing
so I think there's
and using its own labeler code.
piggybacking for a lot of purposes. Piggybacking is not a thing that CMS permits for this purpose only. And so what we are saying is that sort of once Servier is the manufacturer of the drug, has acquired the drug, they may.
I'm sorry, I'm very sorry to interrupt, but you just said two very different things. When Servier has manufactured the drug, and then you said once they have owned the drug, but those are two very different things.
Correct.
What is required to piggyback? Do you have to actually have manufactured? If you're a manufacturer, then you can piggyback on someone else's agreement.
I believe if you own it, you can also piggyback, although I'm not positive about that. And the distinction, I mean, just to be really clear, is that there are a lot of different circumstances in Part D where it's very important that you have a program agreement that covers a particular drug. And so there may be other circumstances where, even if Servier were not manufacturing Tibsovo, it will be important that the Tibsovo that Servier is selling be covered by a program agreement. And at least for those purposes, CMS is willing to let the acquiring manufacturer piggyback on the old manufacturer's agreement until they update their own agreement. And
Is this a fair answer to Judge Millett's question, which is you're not saying that there was piggybacking here. What you are saying is that the rationale of the alternative holding would foreclose piggybacking in other circumstances where you want it to be allowed.
Correct. I think both with respect to this very particular application of determining specified small manufacturers, but also with respect to, again, sort of Part D generally, where the ability to piggyback comes up. My understanding or came up.
I get the concern. I guess I'm not entirely sure why this whole piggybacking thing is consistent with the statute.
So my understanding, Your Honor, is that
There is a statutory requirement that the drug has to be covered by an agreement of the manufacturer for that year.
So my understanding is that is CMS's longstanding practice. I mean, Congress is obviously enacting this provision against the backdrop of that longstanding practice. I think if we were sort of forced to argue about how to interpret the statute, we would rely quite heavily on that pre-existing practice.
Really? We're going to assume Congress understands what this piggybacking thing is when I don't, struggling with it?
Yeah, I think
if you can't define it clearly, then we can't assume Congress knew about it.
I think Congress certainly understands I think the court can assume that Congress understands the general concept in this case, or at least intends to not upset CMS's long-settled practices in this area. That being said, I think for purposes of this court's review, all the court needs to say is that the government is affirmatively waiving the argument. And I do think that the sort of party presentation principles that my friend on the other side discussed are sort of constraining in a way that I think would overcome the usual ability to affirm on grounds sort of not reached by the district court or on other grounds supported by the record. I think in this case, we are telling you we do not think that that is how CMS interprets and applies the statute. It's not something that we would defend. It's not something we would apply in the first instance.
What case says that we assume Congress is aware of agency longstanding practices at this level of obscurity?
I'm not going to be able to cite a case for you for that principle.
Right, so I don't know why we assume Congress legislated again. I mean, you guys could try arguing it, but you're going to have a pretty clear understanding of and consistent application of piggybacking. And this was a 1-year situation here, right?
I mean, again, this was a 1-year situation, but just to be like really clear about this, Part D coverage is only available for drugs that are listed on a program agreement. And so my understanding is that like from the beginning or close to the beginning, CMS has permitted this sort of, whether it's attribution of one agreement to another to the acquiring manufacturer or sort of allowing manufacturers to have both be considered to be on the agreement in some sense to ensure that when you have drugs moving from one manufacturer to another, that there's not a break in the ability to cover those drugs. And that I think comes up in a number of different contexts, not just in this very specialized context. Again, we'd be happy to sort of provide more briefing on that if the court would like it. I think for this court's purposes, though, all the court would need to say is that if it wants to say anything, that the argument has been very affirmatively waived by the government, and party presentation principles would constrain you from reaching it, notwithstanding that waiver. There are no other questions.
I'm not sure we're constrained, but you might have prudential considerations, but anyway.
Any more questions? No. All right. Thank you. Thank you very much, guys. Okay, Mr. Purdue, we will give you 3 minutes. Thank you. Sorry, Council.
Thank you, Your Honor. A couple points. First, I'd like to point, Judge Millett, point you to the FDA's National Drug Code regulations. They are cited on page 13 of our opening brief, and they say that the labeler code in the NDC, it can indicate a person who engages in manufacturing, repacking, relabeling, or private label distribution of a drug. So it doesn't necessarily indicate the manufacturer. Here, it actually indicates the private label distributor. There was a question about whether it's a problem that multiple manufacturers could meet the definition for the same drug or unit. I don't think that's a problem here. That's a feature of the government's reading of the statute. It's a feature of our reading of the statute too. And it's not a problem for either of us because it's not like they're going to be duplicate discounts here. Again, they're not going to be duplicate discounts here. You're not trying to give discounts for historical transactions that happened back in 2021. You're doing discounts moving forward. I think the most important point I want to leave this court with is that you got a lot of detailed explanations from the government today, from the podium, about how they view the statute. And if you put all of those explanations side by side with the denial that CMS actually issued on JA 119 and 120, there is a huge disconnect. None of the government's explanations appear in JA 119 and 120. So I think the easiest path for this court is to simply remand for explanation from the agency. We told them we own the NDA. We are responsible for the manufacturing. That's how this agency administers identical manufacturer definitions in 2 other statutes. At a minimum, we were entitled to an explanation for why they were using the labeler code as a proxy instead of the NDA. I think you heard from the government today a couple times that labeler code is at best a proxy or a first cut. They acknowledge the possibility that it could be something else, that another entity could be the one that actually meets the statutory definition.
Because they've already explained that, yeah, but that doesn't matter in this case because as they read the definition of manufacturer, You didn't do it.
But CMS certainly did not say
Again,
that.
I mean, that's,
CMS certainly did not say that in the denial that they gave us at JA 119 and 120. So I think at a minimum, under Chenery, this court has.
If we think that we can and should resolve all of the legal questions, and we do so against you, what's left of the arbitrary and capricious? Seemed like a lot of those points are downstream from the legal dispute.
So I think there's the possibility of when they have to give an explanation of them seeing the light as we see it. I think there was a procedural problem.
Assume you lose on your contrary to law.
I understand, but
what's left to be remanded?
So there's the possibility if they're going to use some kind of proxy for the manufacturer, they could use labeler code, but NDA is another possibility and they have to decide which one of those makes sense. I think beyond that, though, I do want to make clear there's a procedural problem here as to why we didn't put in more evidence at the time. At the time, the government told us, the CMS told us they were not open to considering the very information that they are now faulting us for not providing. So that's in the guidance at JA 55. They said that they would consider three things: Medicare Part B claims data, Part D PDE data, and ownership information submitted by manufacturers. That's it. So in our recalculation request, we put ownership information front and center. Then they came back in the denial and said, actually, even that additional ownership information that you gave us, it goes beyond the guidance, it goes beyond the methodology, so we're not going to consider it. They then said the same thing to Pharmaceuticals when they put in additional evidence that went beyond the PDE data. So now here in litigation, they're saying, actually, the problem was you didn't give us a different kind of information about specific activities that you took with respect to specific TIPSOVO units. If they had told us at the time that they were open to considering that kind of evidence, we could have put it in front of them at the time. And if we are given an opportunity, if there's any kind of remand to the agency, we'll put that before them and they can evaluate it.
great. Thank you very much, counsel. To both counsel, the case is submitted.
Thank you.
Good. Right. Okay. Need 5 minutes. 5 minutes.
Sorry, excuse me. We're going to take a quick 5-minute recess.
Stand. This honorable will now be the represent.
She used to live with my father. Oh, yes.
Stand, please. This honorable court is again in session. Be seated, please. Case number 24-1253 et al. East Tennessee Petitioner versus Federal Energy Regulatory Commission. Mr. Regula for the petitioner, Mr. Ediger for the respondent, Mr. Johnson for the intervener.
Morning or afternoon now. Good afternoon.
Good afternoon, Your Honors. May it please the court, Ryan Regula from Stella Wimmer, here on behalf of petitioner East Tennessee Group. I'd like to reserve 3 minutes for rebuttal, please. Your Honors, this case involves an appeal of an order of the Federal Energy Regulatory Commission, which granted Intervenor Pipeline both, one, a certificate under Section 7C of the Natural Gas Act to construct an addition to the pipeline system known as the SAP project, and two, a predetermination that the pipeline could recover from its shippers the entire $390 million price tag of this project. Petitioner is not challenging the certificate for construction. Rather, we are challenging the FERC's grant of predetermination that the entirety of the $390 million cost of this project should be borne by the pipeline shippers. Petitioner has two arguments, one, due process, and two, arbitrary and capricious. We'll focus on due process first.
But so before you get to that, my understanding is, and correct me if I'm wrong, that a Section 4 proceeding is underway now.
That is correct.
And that in that proceeding, I think maybe you or at least others have argued about how these costs of these pipeline enhancements should be allocated, obviously consistent with your current view that it should go to more recent customers. Is that correct?
There is a Section 4 rate case going on currently. I am not involved in it, but my understanding is correct that there are an issue, and that issue is currently regarding allocation. I'm focusing on the predetermination, that the predetermination itself should be sent to a Section 4 rate case to determine whether it should be the entire shippers, the new shippers, or the current shippers that are currently on the line.
Could the Section 4 proceeding that's underway make that same decision? That could it be decided there by the commission that the only fair way, based on all the evidence, whatever evidence comes in there, I'm not saying they would, but could they decide that, you're right, either the vast majority, 99%, or maybe even 100% has to be allocated to this group of shippers and not this group of shippers?
Your Honor, I don't think so. I understand where you're going. Because of the commission already issuing a determination on predetermination of rolled-in rates in this particular case, via its order from May 2024, that price tag is already kind of baked in the $390 million. So the rate case is my
understanding. Is there, but you said you're not challenging the pipeline construction. The price tag's there, but and the fact that it's going to be paid by existing customers as opposed to people who wish to come in, maybe, but by existing customers, seems to already be baked in. But which existing customers will pay, or which will pay the bulk of this expense? That's exactly what the Section 4 proceeding is going to sort out, correct?
Yes.
And if the Section 4 proceeding ended up saying that your clients ended up paying 1%, and newer shippers end up paying 99%, would that not essentially solve your problem here?
Yeah, I think my distinction would be the allocation of costs versus the total sum of $390 million. And our argument is that the $390 million price tag, there was other methods that could be used, could be evaluated to get to that dollar figure out before we even get to the allocation. So I'm bifurcating the two issues.
I thought your argument in this case as well was that we shouldn't have to pay, other people should have to pay.
Correct.
I didn't see an argument in briefs here that they got the math wrong.
Understood, but in terms of the Section 4 kind of allocation that you're kind of getting at, I just want to make the distinction that the Section 4 case that's happening elsewhere, it's more or less regarding the allocation. Again, you're right. We're arguing that we don't think we should have to pay the $390 million, or the shippers should not be, that are currently on the pipeline. I'm in agreement.
And you're arguing that in that proceeding?
We are.
And if you win, I mean, obviously you hope to win.
I would hope to win,
If you
yes.
prevail,
Yes.
then everything's fine.
I would agree, Your Honor.
Nothing about this case. It doesn't matter what happened in this case.
Can you also challenge under Section 5?
Possibly, Your Honor. The issue is that we already currently have an order on the books.
Order that says we'll go to a Section 4 proceeding and figure out how much you pay there. And you can make your representations about we should pay 0 or 1% or whatever, if you think there's some small part that's fair for you to pay. And you can do that there and you might win. And my understanding also is that proceedings on pause for settlement negotiations.
That is correct, Your Honor.
Which, if successful, would also obviate any need to decide this case or any injury you assert from this case.
Correct. And I think for our purpose,
So why should we decide this until we know what happens in the Section 4 proceeding?
we have an order currently enforceable that the FERC has.
Enforceable, it says, look, we've made a judgment here that this should be paid by customers, that this enhances the pipeline capacity and service quality for all customers. So it'll be rolled in rates. But all FERC said was, but who pays exactly how much? We'll sort that out later. And I raise this because you were about to start about due process, and I don't understand why this Section 4 proceeding isn't part of the due process you get here.
Sure, Your Honor. And if the court would be inclined to go that direction, that's a fair ruling. I think from our perspective,
Whether we should, or am I misunderstanding things? I mean, it's sort of two things. One, should we wait? Especially if you're going to resolve it by settlement. But two, I'm also asking, so that's one if you can answer. But the second question is, don't we have to factor in for purposes of your due process concerns that you're getting still more, FERC said at the time, this is not the end of the story. There's going to be a Section 4 proceeding, and you can make all the showings you want in the world in that Section 4 proceeding about you guys not, your group, your client not having to pay much. So that's part of the due process you get.
Understood, Your
No one
Honor.
sent you a bill yet.
No one has sent us a bill. No. No,
So can you answer my practical question? Should we wait? And then can you tell, then as you address your due process argument, how you have a due process concern, given that you're still in the middle of getting your process through the Section 4 proceeding?
sure. Answering your initial question first, it's our position that you should rule on the issue now rather than at the Section 4 rate hearing, only because we've gone through the proceeding and and FERC has already made the determination via the SAP application way back that was filed in 2023, had a final order that came out a year later. That the pipeline has relied upon in terms of constructing. We are not challenging the construction of the pipeline addition, but we are challenging the allocation, or I should say the price tag of this project and the feasibility of that $390 million price tag. So we're kind of, if we're waiting to the Section 4 rate case, we're behind the 8 ball already.
So the process argument?
Sure. Regarding the due process argument, petitioners contend that the FERC and the pipeline have stonewalled petitioners' data requests and in fact denied our due process.
Your main argument on due process is that FERC acted unconstitutionally or at least arbitrarily in granting this order before you had the CEII information.
Yes.
But there's a certificate proceeding and the applicant has to put in all the information supporting the application that FERC requires. And you intervened and had a chance to put in whatever information you want to require. And your complaint is that you didn't have access to agency information in, wholly apart from the record of the adjudication. Sounds like you're saying there's a constitutional entitlement to discovery. Doesn't seem hugely plausible to me.
Sure. And just taking a step back, we're looking for the CEI information because we want to test the allegation that the pipeline has alleged that there's this loss of displacement gas, and that's actually happening. So we want to be able to compare the historical numbers to understand the progression flows and whether or not that this project or the $390 million cost of this project is.
None of it is in the record of this adjudication.
Sure. But we have requested the information, shortly after the SAP project, the application was filed.
And the request was not made on the docket such that FERC would have known that right away. But then later on, you got the information that you asked for.
In FERC's May 2024 letter response to us granting us the CEI information, they acknowledged that we requested it in June 5th of 2023, so a year earlier. So by the time we got the information, which was in fact August of 2024, the SAP order approving the application for the pipeline addition, that had already been approved. So we have not had an opportunity to look at the information until after the fact.
Is that Form 567 information also in the Exhibit G's, essentially the data flow information?
Yeah, so there's a distinction to be made. And let me rephrase my yes. The Exhibit G contains a snapshot of 2 times of the gas flows, once before construction and another after the construction of the SAP. This snapshot is insufficient to provide or to demonstrate historical patterns or the progression of gas flows to determine the need for the project. And so Exhibit G was filed with the SAP application, but it was filed under seal of confidentiality. Our Form 567, the CEI information, that provides peak and average gas flows on an annual basis. And we first requested the 2022 Form 567, which was delayed 14 months before we received it. And then we subsequently requested the 2023 version as well, which that was provided almost instantaneously. So to answer your question, The Exhibit G is not the same as Form 567. There are definitely differences.
But FERC did ask for this annual flow data subsequent to the proceeding, but it at least is explained, like they utilize this information that you're requesting.
In your application in terms of approving the certificate?
Yes.
Whether FERC used it or not, it wasn't part of the record that we were able to see. I mean, that's part of our complaint. There's information out there that we haven't seen that we are entitled as interveners to be able to assess.
Even now, between the Form 557 and the Exhibit Gs, you're saying there's additional information?
No, the information now has been provided, and it was provided after, our deemed denial to our request for rehearing.
But is that information explained in FERC's later orders?
No, to my knowledge, Your Honor, it's not upon recollection.
Okay.
Thank you. Your Honor, the petitioners are going to contend that the stonewalling of our data requests, which we have described, provided us as an opportunity to make our case, and that we as the petitioners failed to avail ourselves of the opportunity of that information, and we were provided all the process that we were entitled. But FERC misses the point, because this case turns on the principle that due process delayed is due process denied. And as mentioned, we didn't receive the information until months after the SAP certificate was already approved by FERC. In this case, the record demonstrates that the opportunity in which FERC
care about this. You told us you don't care about the SAP certificate being approved. You can just care about who pays for it.
Well, the SAP certificate had two elements. One, to construct the addition of the pipeline system, but it also had the predetermination that the pipeline could recover from its shippers the entire $390 million price tag of the project. We care about the price tag.
Okay, so you don't care about the price tag, you care about the allocation.
Both, yes.
Well, nowhere in your brief do you challenge the price tag. I see no arguments about they spent too much money.
Sure, okay.
I keep getting confused when you talk about challenging the price tag. You're challenging the allocation.
Yeah, I suppose I'm baking the two of them into one, but I understand your point, Your
Okay.
Honor.
And so you got the information. Well, first of all, when you asked FERC for the information, when you filed a request with FERC, did you tell that office that there was urgency?
Well, we made the initial request in June of 2023, so shortly after.
Urgent, there was ongoing proceeding you needed it for?
We went through the appropriate channels. I don't believe we, requested it being urgent.
Okay, all right. And you make a lot about the delay, but my understanding is that you had to get FERC had to just go through a security clearance process to release this information because it's protected information. And so it's not like you just file and they hand it over to you. They had to make a security clearance determination, right? So it's not something that's going to happen super fast.
I agree with Your Honor.
Okay. So, so are you saying that the amount of time it took for FERC to produce the document was inordinate?
I would agree with that, yes.
It was inordinate?
No, I'm sorry. It was excessive.
From the usual course.
It was, different from the usual course.
How long does it usually take to get this clearance and document?
I don't know, but I could provide you two examples. We requested, in this case, it took 14 months, and then requested the 2023 CI information, and it took a matter of days.
Mm-hmm. But had you already gotten the security clearance by then?
That is correct.
Well, that makes a big difference.
It does.
Okay. All right.
Your Honor, regarding the due process, and just summing up before shifting over to arbitrary and capricious, it's our contention that by not having this information, we lack the ability to meaningfully and timely participate in the SAP application proceedings. And by not having that information.
You said that you didn't say.
I'm sorry?
What would you've had months, years now to look at this document. What would you have said at that hearing and make in the record that you didn't say? Now that you've looked at the document, you've had plenty of time to look at it. What would you have said that you didn't get to say?
Your Honor, I would argue first, before answering your question, that it's a bit of a red herring in terms of we didn't get the information timely, but if we did have the information, we would have been able to test the loss of displacement gas.
You've had plenty
Whether it
of
was
time to
prudent-
test, you've had plenty of time to do that, right?
After the deemed denial and after we
Just
filed a
asking
petition.
you to tell me what you would have said that you wouldn't have said, that you didn't have the opportunity to say.
Sure. We would have tested the ability of the pipeline to have the appropriate capacity, whether it was.
And you would
know,
have tested it, and what would that test have shown? You've had plenty of time to do that test.
Yeah, I don't know what the test would have shown.
I mean, due process has a prejudice requirement.
Yeah, and I would argue that
What is your prejudice?
well, the prejudice was ultimately the price tag and the allocation is what we would argue.
What you have to show is how the absence of this particular document prejudiced you in that it contained information you would have provided, material information you would have provided had you had it in time. And all I hear from you is we would have done an analysis.
Correct. Yes. The Form 567 information is not a red hair. It's not a smoking gun document. It's more information that we're able to test to determine whether or not that the displacement from the gas displacement was as the pipeline was alleging.
Mhm. Did you test?
We did not test.
Why not?
I don't have an answer on why we did not test.
More questions? All right. We'll give you a couple more minutes on rebuttal.
Thank you.
Good afternoon. May it please the court. I'm Scott Edgar for the Federal Energy Regulatory Commission. Judge Millett, I think I want to go to a question you were just asking about whether the work has been done. And I want to refer specifically to pages 21 to 22 of the reply brief, where there's a long block quotation of, I think, a lot of the promises that we just heard more of. And what I just want to point out here is that when the person was typing up those words in September of 2024, figuratively, Form 567 was right next to the keyboard. They had it and they could have made the assertions there, which leads into the primary point that we raise in response to the petition, is that this commission, this agency, takes the rehearing process seriously. And when the issue came to the commission's attention that CEII hadn't been disseminated quickly, the commission acted. And that's the May 29th, 2024 letter. That letter comes a little over a month after the rehearing request, and I might add, before any paper was filed with this court. The commission issued that letter in order to accommodate the desire of the shipper petitioners here to make the argument. As the commission pointed out in the rehearing order, nothing happened after the May letter. And so the commission issued a series of letters subsequently, giving the opportunity for the shippers to make the case that Form 567 somehow detracted from the predetermination determination that was made in the certificate order. By their own admission, that never occurred. This case shouldn't be here today. We should have been able to resolve this issue before the agency without taking more time today of the course time. And that's the way, that's what we believe the Natural Gas Act provides, Section 19, as interpreted by Allegheny at pages, I don't have it in front of me, but Allegheny clearly recognized that one of the arguments we responded to in Allegheny was that, well, these are complicated cases, we need more time. And the response was, well, you have more time. On the deemed denial date that occurred, the commissioner
Hearing goes forward until you file the record.
Precisely, Your Honor. And that's what the commission did here. I think this was provided in the Natural Gas Act, and those opportunities were provided. And I also want to point out, it's interesting about the Exhibit G. That was on file from day one. So that's on the record. And I just want to make some, maybe talk a little bit about what the difference is between Exhibit G and the 587. And the commission talked about that at paragraph 5, note 11. This is at JA 417. And Form 567 is a more system-wide information, whereas Exhibit G, which is required by commission regulation, this is 18 CFR 157.14A8. And I think we appended that to our brief. It's very detailed information. And you can understand why it would be helpful to the commission to have that information, because it requires the pipeline to show us what the project or what the system looks like before the application and what it looks like after. That allows the commission to make the determination on whether the project is needed. Form 567 does something different. It's an annual update of the system, and it allows all companies have to make the filing. It allows the commission to stay on top of what the sort of big picture of the natural gas industry looks like. And again, 587 not required by commission regulations to be put on the record. And what I just want to get back to Exhibit G. The shippers never asked for it until well after the rehearing deadline. So they were flying blind through this process. This is the information required by commission regulation to be put on the record, and shippers never asked for it until well after the rehearing request. And they did so by a process under G4 of the commission's regulations that govern CEII data. In our brief, we talked about the differences between G4 and G5, and the Exhibit G was released. It's unfortunate that G is used twice here, but I'm sorry for that confusion. But that pipeline released the Exhibit G information under G4 of 388.13, and that was all on the record. And if counterfactually, had pipeline for some reason refused to do that, they would have or thought that wasn't appropriate, they would have had to make a filing before the commission, and then the commission would have had to rule on it. And then that, of course, would become an issue that could be subject to judicial review. By contrast, this form is not on the record. It has never been on the record, and it's not on the record to this day. And I think what we just heard is my friends for the shippers don't even know for sure that it supports their position. And we have no way of testing that because, as I say, it's not on the record. They requested it through G5 of the CEI regulations, which was appropriate, and they went through the process of asking through the CEI coordinator to get that information, and eventually it was released. As the commission points out in the rehearing order, that release occurs after the certificate order, and that's why the commission provided the process.
Can I ask you about the status of the Section 4 rate proceeding? One, assuming that they decide today to finally decide what they want to do with this information, would they use that to argue about allocation in the Section 4 rate proceeding? If they think this document they finally got helps them with that argument as to whether they should have to pay much, if anything.
I'm sorry, I'm just trying to finish my sentence. I think you already got the idea, but can't they argue about how much they should pay, if anything, in the Section 4 proceeding? It is an ongoing proceeding. I think if I can answer it this way, the presumption, the predetermination has been made in this case, in the certificate order, and we're asking the court to affirm that. And that is a sort of high-level determination that existing shippers are responsible for this project because it helps them. Reliability, flexibility. Now, within that, the equitable allocation of those costs among existing shippers, that could be a live issue. I don't want to get too far, and I don't know what's going on exactly in Section 4, what the issue, the Section 4 case, and what the issues are, but those are potential issues that could come up. But what's happened here is again a very top level determination, presumption to be applied in the next case. And I think we cited the Texas Eastern case.
Is a presumption that every shipper will pay something, but the Section 4 proceeding will decide who pays how much?
I think that sounds accurate. It's more granular, more detailed, and it'll be part of the tariff.
I think you said?
I'm sorry.
And it's sort of an equitable analysis?
Yes.
Was there any reason that you denied the rehearing request first and then gave the data?
I do believe so. I think it took the commission some time to decide what was appropriate. I think that it was an evolving process. So and I think it became apparent from the rehearing request, what was necessary is that the commission believed that information needed to be released, and the commission, I think the only way to read this rehearing or the rehearing order is to realize that the commission believed that the group needed an opportunity to comment, to receive the information and to comment on it, and to get that argument before the commission. And there's a lot of arguments that they've made about how the commission wouldn't, like this was some kind of trap, and the commission wasn't going to really take that seriously. But I think the existence of the letters themselves belie that argument. And in addition, had the commission, they really followed through, had they really taken the information and made real substantive arguments like they promised they can, and then the commission had rejected it, we'd be having a different conversation today, and I'd be standing here trying to defend that. And by their argument or their assumptions of their argument, I'd have a hard time with those arguments. I'd have a hard time today. And so I think the better reading is that the 567 is not relevant, not helpful, and that's why it hasn't been ever put on the record. Thank you very much.
Thank you, counsel. We'll hear from the intervener now.
Your Honors, and may it please the court, Joshua Johnson for respondent intervener, East Tennessee Natural Gas. I think that the group's argument today has significantly narrowed the issues before the court. If I'm understanding the group correctly, their position seems to be that they are not challenging a project that benefits existing shippers. They just don't want those existing shippers as a whole to have to pay for the project. But that's not how the Natural Gas Act works. Under the Natural Gas Act, natural gas companies can recover their costs and a reasonable rate of return through the rates that they charge. For this particular project, there's no dispute.
I'm not sure at this point, if there's going to be an allocation proceeding, and if they end up getting happy there, that they really care if some other shippers have to pick up a big tab.
But in this proceeding, and I agree that there's a separate question about allocation in the Section 4
FERC did not decide in this case. FERC did not decide that in this case.
Correct. That's absolutely right.
Sure, we'll roll in. This isn't some outside customer who wants to come in and should pay for this thing to connect to their plant wherever it is. This is something that just sort of benefits the whole pipeline for everybody who's already on it. But you all go figure out later in a Section 4 proceeding who pays how much.
And I have no dispute with anything that you just said, Judge Millett, but the group in this proceeding is still challenging the roll-in predetermination. They're asking the court to vacate that. So they're asking the court to undermine the basic decision that the existing shippers, as opposed to, I suppose, the pipeline, should pay for the costs of this project. And the court, I think, can easily reject that argument and say that any issues about cost allocation should be left to the Section 4 proceeding. That's actually what FERC said in its certificate order. But in terms of, there have also been
Do you have any update on the status of the Section 4 proceeding?
Section 4 proceedings are very lengthy proceedings, so I still think that in terms of the life of the proceeding, we're still pretty early, and in terms of the parties defining what arguments are going to be presented. I would say that I think that the court should issue a decision here that there is a ripe dispute about the basic fundamental question of whether the roll-in predetermination should stand. And what that clarifies is that existing shippers as a whole will cover the costs of the project through new rates and in a rate proceeding. And the court, we believe, should deny the petition for review, allow that roll-in predetermination to stand, and then any questions about allocation or attribution can be left to the Section 4 proceeding. If there are no further questions, thank you.
Thank you, counsel. I'll give you 2 minutes for a rebuttal, Mr. Regula.
Thank you, Your Honor. Just very quickly, following up on the line of statements by the intervener pipeline, talking about the rolled-in predetermination. One of our problems, and this goes just very quickly to our arbitrary and capricious argument, is that the FERC elevated one factor of its policy statement, and that's treating the absence of new capacity as automatically justifying the rolled-in rates. And it disregarded other factors in the policy statement, specifically policy statement at pages 19 to 22, which we also said in our brief regarding abandoning, balancing, disregarding prudence and cost causation principles. And to be frank, FERC didn't weigh the purported reliability benefits against rate impacts and compare the appropriate costs. So as it pertains, and I understand I've got just a minute or two, I just wanted to flag that again for our arbitrary and capricious, that the policy statement and how it is applied for the predetermination is part of our contention as well, which will not be resolved at the rate, at the Section 4 rate hearing. As my friends on the other side have mentioned, the predetermination is.
You got a forfeiture problem on your policy statement argument.
Yes. And then just very quickly, tying the loop regarding us receiving the data. We received the data on August 16th, 2024. We were given 2 weeks to respond. I'm sorry, 2 weeks later on August 28th, we were told to respond to the data request. Well, 2 days after that, FERC granted the certificate to construct. So as we're kind of looking into the information, the amount of meaningful and timely participation by FERC's own actions.
You're not challenging the pipeline and its construction, so that nothing about construction.
Correct.
Affects. Okay, so I'm not sure why that matters.
Understood, Your Honor. That's all I have. Thank you, Your Honor, and we would request that the court remand the predetermination of rates. Thank you.
Thank you. The case is submitted. Thank you to both counsel.
This honorable court has adjourned until this afternoon at 2 p.m.